of urgent determination, my lord, Justice Basu, my lord. But the petitioner took admission for pursuing B.Ed course for the session 24-26, my lord. But their registration is withheld, my lord. That petition is pending, my lord. Meantime, my lord, the university has issued notice for, my lord, that admission of students in the B.Ed course for the session 25-27, my lord.
When the admission shall begin?
My lord, the last date of making online applications is 7th November, my lord, Friday. My lord, I have served notice, my lord, upon the learned advocate of the university.
Of previous year.
24-26.
In this
But they are registered.
upon them to apply. If they want, they can apply.
But their registrations are withheld, my lord. Yes.
This is the
All right, let's see. Come tomorrow.
Tomorrow is holiday, madam.
6th.
Great.
6th, motion top.
Great.
Motion top. Motion top. Yes.
Madam.
Yes. Appellate side mentioning? All right.
Lordship, may I be permitted to mention a law matter?
Original
that-
side?
It is in appellate.
Seniors are there. Appellate side?
Yes, appellate
Yes.
side. I'm here to mention for extension of interim order, which is expiring on 7th of November.
In which matter?
Pavot promoters versus KMD and Anna.
No. It's an assigned or
It is
it's
an
a
assigned matter, Your Lordship.
assigned matter.
Yes, Your Lordship.
Assigned matter interim order is expiring.
Yes, Your Lordship. It was. Can I show the assignment letter?
Yes.
Notification and the letter.
কি এগুলো? Where is the order?
Your Lordship, by this notification, there's a whole thing.
Where's the order?
Your Lordship, last the matter was taken up by Honorable Justice Shubhanda Shamanto. After that, he released the matter on his personal ground. Then we wrote a letter, and then the matter was assigned to Your Lordship.
All right. To be mentioned, extension of interim order. লিখে 6 তারিখে দিয়ে দিন, তারপর দেখছি।
Highly obliged.
To be mentioned, extension of interim order. এটা লিখে লিস্ট করে দিন, তারপর দেখছি। পাখাটা চালাতে বলো।
Highly obliged, my Lordship.
এই পাখাটা চালাতে বলো। হ্যাঁ। অ্যারেস্ট হয়েছে কেন? থাক আর কিছু করতে হবে না, ঘোরাতে হবে না। আর আরেকটা কি? হ্যাঁ, তাহলে 2 PM দিয়ে দিন, সাপ্লিমেন্টারি লিস্ট করুন। হ্যাঁ। Huh?
This matter, I appear for the judgment letter who has been arrested today and it will brought before your lordship. Taken up before
2 PM. Yes, list করে দিন 2 PM.
May I have your lord's leave to mention a commercial suit, your lordship?
Take the microphone.
A commercial suit, your lordship.
Huh?
Commercial suit.
হ্যাঁ,
Writ of
suit for hearing.
undefended to appear as an undefended. The writ of summons
Mr. Jain, wait for some time. Let me do the
Lordship,
work
I-
on this list.
mentioned before September. I was told to mention after vacation. I will anytime in December, your lordship.
This will first let me clear up this entire bunch, because I tell you the practical difficulty. I find that the suits are fixed with the time
Exactly.
and date. Now, in many of the suits, 2 witnesses have already been examined. Cross-examination is in progress. 1 witness is in progress. Now, unless I know what is the plaint, what is the written statement, what is the issue, how can I take up these?
Definitely, but your lordship, I was humbly praying.
So what I try to follow, I have already today's list. I have given kota suit ache amar 4টে suit দিয়ে দিয়েছো তো এই suit হ্যাঁ those 4 suits yesterday I sorted out and ওই লিস্টটা কোথায় বাকি 30টা চেপেছে কোথায় পেছনে দেখাও হ্যাঁ এই তো
Warning list is there.
yes so what I am thinking one by one I will take up these suits right then if one is disposed of the first one from the warning list will come
So these are contested suits, your lordship.
very well
There are number of matters which are uncontested.
sir I cannot take up like that
Any particular day and time for few hours, your lordship can dispose of. We have
I cannot let me start working on this list then I will see I have already given my instructions on the list when I should take up which matters
with respect to undefended suits, your lordship would kindly consider it because undefended suits will not
then
take
again
much
time has to be encroached from new motion
Sometime any day, Friday for
Friday I have to
That-
take up assigned and
Assigned.
contempt
any day, your lordship.
any
sir,
day
because
then I have to take I
undefended
have
can
to
be
then
cleared off.
the time has to be encroached from new motion 2 days new motion are there what to do sir you please consider the instructions I'm open for suggestion I'm open for suggestions first you consider the instructions then if a fruitful suggestion is there give it to me I'm open for suggestions but otherwise how can I take up
So far as the bar is concerned, the list should
Huh?
roll. List should roll because undefended suit will also get
list
stuck
to
up.
roll correct
That's
but
true.
if 30 matters are there in which one witness examined 2 witnesses are left cross examination left now one day will come when 30 matters will
Our list,
absolutely I will not be able to
Lordship-
tackle that
Lordship would kind- That's
the usual practice what we have seen I can try to follow that one suit I will complete the next suit will come I know it will be time consuming but what to do sir because suppose you take a situation I take up one suit which is fixed today at let's say 11:45 there first witness examination in chief completed cross will commence so either he has to complete the cross of that witness or I will have to take up for 1 hour or half an hour
that is the practice going on.
right now then again the next suit again a cross examination again for half an hour then the next suit sir I will not be able to manage the list like that I will not be able to so let me proceed in my own way as that's why I have published the instructions but I am absolutely open to suggestions if any fruitful practical solution comes to this I'm open to suggestions no problem think over it and I'm telling it to all of you think over it give some fruitful suggestions yes
And may be permitted to mention the assigned matter, my lord. This is the 10F Companies Act matter, your lordship was hearing before.
sir not now it will be published in the list original side list আমার অ্যাসাইন ম্যাটার গুলো ওই নেক্সট বৃহস্পতিবারের পরের বৃহস্পতিবার না অ্যাসাইন আমার যেদিন আছে শুক্রবার হ্যাঁ ওই তাহলে এই শুক্রবার এন্টায়ার লিস্ট অফ অ্যাসাইন ম্যাটার্স ইন দি অরিজিনাল সাইট পাবলিশ করে দাও একে যেদিন যেরকম পারবো নেব
It appear on this Friday, my lord.
নেক্সট
Lord, may I be permitted to mention that a commercial suit, my lord?
Huh?
May I mention a commercial suit, my lord? I'm appearing for different numbers 5 to
ফর
15.
হিয়ারিং
No, my lord. The time to file written statement is finally expiring on this Friday. My written statement is affirmed. I need your lordship's leave to file it in the department, and I have to take out an application for extension of the period of beyond 30
according
days.
to me that application is mandatory
Yes, that
and that
application I'm
should
carrying.
that is condition precedent
Yes, I'm carrying the application.
unless that application comes
Yes.
how show me the law that I can give you leave subject to the result of that application
But,
So-
then will kindly keep it in the list on 6 because we have judgments of our court. The practice that is being followed is application is filed without prejudice or without any rights. the detention statement is filed in the department, it is subject to the result of the application. That is what being followed now in the
Leave was granted on the
leave is granted to file the the written statement. We file it in the department, and then when the application is allowed, then it is accepted. If the application is rejected, the same automatically it goes out of the record.
This is between 30 days and 90 days.
Yes, my lord.
30 and 90.
90 and 90. So, my lord, 120 days is expiring on this Friday. So, with your lordship's leave, I'll be able to file it in the department, it's affirmed. And I am also carrying the application in my hand. I'll be filing it today.
Now tell me one thing. After 30 days, you have to come up with an application. If the court satisfies, yes, then within 120 days, you can file.
My lord,
Right? That's the law.
that's it.
Beyond 120 days, doors are closed.
Yes. No, there is no other option
No
left.
option. Now, if I grant to leave today, you take out an application tomorrow. Why don't you take out the
But
application?
the problem is this problem is the application is in master summons
Huh,
and it takes 3 days.
that's right.
So, my lord, today we are on
So why do you have to wait for last 1 week
after reopening, my lord, because before the
before reopening?
interim order was contested up on the last day of the vacation, 29th. We, in fact, well, after reopening, we got the interim order. That was rejected.
How does it
And there
matter?
was a
How
demanded
does it
application.
matter with the interim
There
order?
was also a demanded application being heard. That was also rejected. So we were of the view that
When
was
the
for
demurrer was rejected?
29th of October. And then we urgently prepared. Written statement was ready, but the without application, I could not have filed this. So I had affirmed it.
Show me an order. What type of
Yes.
order it was passed
Yes,
previously?
yes, No, the 29th October order. But I am not carrying a hard copy.
What kind of
Give me the number. Any order, I am bringing it.
Oh,
Fetching it out.
yes, my lord, then kindly keep it. My lord, I can come back at 2 o'clock
Come at 2
with such an order.
Yes.
My lord,
Come at
the
2
order that
o'clock.
has generally
Come at
passed.
2 o'clock.
Very well. We'll come back at 1:30. I'm not with the
1:30.
1:15 and with the same prayer, my lord, with the copy of an order.
You come at 2 o'clock.
Very well, 2 o'clock. I'll come back.
Yes.
Lord, may I be permitted to mention a suit, my lord? A suit for recovery of money. Now, my lord, defendants have not
Not
yet
now,
appeared
sir.
with their
Let me do the work on the pending suits then.
Understood.
Time mention a commercial suit, your lordship.
Take the microphone, madam.
I have your lordship's kind leave to
Huh?
mention.
I can't hear you, madam. Take it properly. Yes.
I have your lordship's kind leave to mention a commercial suit. CS.Com 8 of 2023. I appear for the plaintiff, your lordship. It's an undefended suit.
For hearing.
No, for final arguments, it was substantially heard before Honorable Justice Krishna,
So,
your lordship. I
look
can
at it.
release the
So how do I entertain the final argument?
your lordship. I'm praying that your lordship.
I have to
release
read
the
from
matter.
this very first sentence of the plaint. Otherwise, how do I know?
Lordship, I was praying that your lordship may kindly release the matter
Release.
Yes.
Oh, very good.
so that could
To be mentioned. এটা তুমি লিখে নাও to be mentioned. এটা for release. To be mentioned for release.
Lord, may I be permitted to mention a matter? In this, I filed a WS to the counter statement. I'm for the plaintiff.
Counter statement. Counter claim.
Counterclaim filed by the defendants. I was 6 days delay to file. It was to be filed within 30 days. After 6
Written
days,
statement.
written statement to the counter claim.
Forget about
with the-
counter claim. Written statement, you have to file 30 days plus 122 days.
Then within 120 days, but after 30 days, leave was granted to file the WS in the department. I filed only the formal acceptance of the court is required. So
So
let
the
it
application must come up. Otherwise, how can I? 30 days,
yes, my lord.
no rigor. 30 days plus, you have to apply whether you are permitted to be allowed to use the extended period of further 120. So where is that application?
Lord, leave was taken on the last day.
No, that's the problem. That's the problem. Leave will not override the statutory provision. That's the problem. That's why I asked your learned friend, someone who has mentioned it, to come at 2 o'clock.
And I'll file a formal application. If
Leave is not the sacrosanct when statute is clear. Leave cannot alter or amend the law.
Well, Lordship, kind leave to mention two suits, Your Lordship. These two suits were filed.
Suits for hearing.
No, Your Lordship, it's at the interim stage. The applications are being heard.
You are mentioning the interlocutory
I
application.
was mentioning the interlocutory application.
New motion or adjourn motion?
Adjourn motion.
Adjourn motion.
An interim order has been passed, Your Lordship, kindly. One of the suits has appeared in the list today. The other has not. The only difficulty is
Sir, suit or application?
the application. The other has not appeared in the list.
So it will appear in the monthly list of December.
difficulty is, Lordship, both the interim orders are expiring today. So one of the suits has appeared, the order of which is expiring today, but the other has not. The other application has not appeared.
To be mentioned.
My lord,
I can
am
at best entertain you as to be mentioned.
But, Your Lordship, if it goes to tomorrow, then
Tomorrow, yes.
no, if it goes to tomorrow, Your Lordship, if it can be taken up today, the other matter which has not appeared. One of the interim applications.
So I'm directing it to appear on to be mentioned day after tomorrow.
The interim order is expiring today, Your Lordship, for both the order. If I may show the order, Your Lordship will perhaps. If I may show the order. So now, there are two suits, Your Lordship, for which the applications were almost being heard analogously. Now, one of the applications is appearing today for one of the suits, but the other application, which is for the other suit, has not appeared.
Motion and chamber. New motion and new chamber.
I think it's new chamber application. I believe it's under the new chamber applications.
Both. Sir, you're
appearing
not to, you just go and ascertain and come back.
It's today in the list under new chamber applications. I believe.
Show me which item.
Item number 12, Your Lordship. Suit number 680 of 2024. Your Lordship.
Item number 12 is new chamber application.
Yes. So one of them is appearing.
One of them is in the same suit.
Both applications, one application in each suit, Your Lordship. There are two suits, 680 of 2024.
Two suits.
Two suits.
Right.
Which
one suit with the required application is appearing
today.
The second suit with the application is not appearing. So that you mentioned it will appear on the next day.
The only difficulty would be that the interim order would have expired. It's expiring today. That is what the order also says, Your Lordship. That is why I handed over the order. I also have an order where the suits were being heard analogously as well, Your Lordship. If I may hand that up.
This is a new motion matter or chamber?
Chamber.
My lord, I am appearing.
Which one is not appearing? That is also chamber.
Yes. There is another application which is filed by them, but that is separate.
My lord, I am appearing.
These has to be chamber.
The application which you are now citing the example not appearing in the list.
Yes.
It is also a chamber matter.
Yes.
What is the nature of the application?
It is for an interim injunction on their bank accounts so that they may not be cleared out. And
so how that can be in chamber?
It had appeared under chamber, Your Lordship, on a previous date as well. It was heard under that. I perhaps would have to go back and check the list.
So this is a new motion matter.
Yes, my lord.
Receiving alternate instructions.
My lord.
Your Lordship, I am appearing for the defendant number 2, Your Lordship. These ought to appear under the adjourn motion because the ad interim stage is already over. Now we have filed our affidavits. We have filed already.
So
you have not even told that.
I think it was an adjourn. That is why the new chamber it has appeared under, but perhaps that is because they have also filed an application.
Our applications are at nascent stage, Your Lordship. We have only filed the applications and direction for affidavits have been granted.
Nature of interim order that is going to expire today?
They are enjoying an injunction on our bank account from operating below a certain balance, Your Lordship.
Matters were appeared under adjourn motion and we had heard them on several occasions. Now they have filed an application, so I believe it has gone under new chamber. But both these
Sir, you can't be concerned with your own application, which is going to expire today.
That is exactly where I am.
That is chamber or that is new motion?
It should have been adjourn motion, Your Lordship, because it was heard on multiple occasions.
So how is it appearing under the heading new chamber?
Perhaps because they have filed an application.
Your Lord.
Your application may appear as new chamber.
Your Lordship, if I may.
Yes.
If I may, Your Lordship. The reason being, these days after the incoming of the CIS system, it always, your lordship has seen that it always appears under the heading suit. Under the suit, whatever applications are there, all the applications appear at the same time, your lordship.
Previously also the suit number was mentioned. And
Yes,
then
your lordship.
interlocutory applications.
The only difficulty that these days we have faced.
That does not mean suit is appearing for the
No,
hearing.
not the suit, your lordship. But even if we are mentioning for a certain application, your lordship, it appears under the suit, your lordship. The suit numbers are there, and all the applications appear together. That's the thing.
30 years back also that happened. Suit number has to be there because the
Yes.
moment you draw or draft an interlocutory application, then GA arising in CS.
Yes, your lordship. Now the only difference is previously maybe the applications were different item numbers. Now all the applications clubbed together under the suit appears as one item number.
But maybe, but that
Which is why possibly the new chamber application. Because our application appears under the new chamber application. So all the applications in that suit appear together, not separated. In a cluster now they appear only. So it is.
এটা আমায় কে বোঝাবে ভাই আগে? এখন একটা মামলা দিলে মানে 5টা অ্যাপ্লিকেশন একসঙ্গেই অ্যাপিয়ার করবে?
It has happened before.
ধরো আমি একটা সুটে একটা অ্যাপ্লিকেশন টেক আউট করলাম, তাতে 18টা অ্যাপ্লিকেশন থাকতে পারে, কিন্তু আমার অ্যাপ্লিকেশনটা তো অ্যাপিয়ার করবে একটাই নাম্বারে নাকি 18টা নম্বর অ্যাপিয়ার করবে?
Some courts, actually, in some courts, 18 items are given. 1, 2, 3, 4, 5, 6, 7. In
G1 is
some courts, GS number are given from like a two column. Suit number is 1, but all should come.
Suppose suit is 1, right? And the interlocutory applications are 10, right? The 11th one, plaintiff wants to move. New one. 11th one.
That he has to give a returnable date.
Listen to me. Suppose the 11th application, which the plaintiff wants to move today, or the defendant even wants to move today. What we have seen, I have seen rather. Now I'm grown old. I see. What I have seen, that suit number is mentioned. What we used to draft, GA number such and such, in CS number such and such. So the new motion or new chamber, it comes like that. GA, CS. There may be 18 other GA, but the one you want to move, that will only appear. Nowadays, what is the practice?
Suppose I want to do a new GA, which is not there. Suppose the returnable date is 7th November.
Correct.
Of all the others. Now, if I want to move
Of all the others.
Yes, maybe 1 to 10 GA. Now, I wanted to move a GA which is 11 GA. Now that will come pursuant to my returnable date given on the form. But that doesn't mean that all the 10 GAs will come on that.
That's precisely I'm asking. They are saying that all the 10 GAs.
Yes. Now, your lordship, on the previous occasion, all the GAs were directed to appear on the same day.
Now,
Hence, it's appearing as a clubbed item.
list today, the GA that is appearing is GA1, which is my GA, the original one. But it could not have appeared in the new chamber applications because the new GAs are theirs. The new applications that they have filed are theirs, but the GA that is appearing
Sir,
with the list is
If
mine.
you that practice, what I have seen, that is what I am asking.
Which is why we are at the
I have seen the practice for 22 years there, that if I have an application to move as a new motion, it will have to come under the heading new motion. It may be so that there are 100 GAs are there under chamber heading. But the GA which is to be appearing as new motion, it will appear only under the heading new motion.
That is where the
So
predicament.
that practice is not there today.
That is there. That is why the predicament, your lordship.
So
because
then why the new motion will be appearing under the heading new chamber?
that is the predicament, your lordship, because these two matters were supposed to expire today, which is why I tried to mention it before, your lordship, yesterday. Perhaps it would have come under a different heading. But then one of them has appeared, but the other has not. And both of
The
them are
one which has appeared,
yes,
that is under the heading chamber.
that is under the heading new chamber application.
New chamber.
New chamber.
The one which has not appeared, that is a new motion. Today you are mentioning?
No, that would also have been an urgent motion. That would also.
That's an urgent motion.
This so is this, Your Lordship, because both the interim applications have been heard at length.
Sir, hard at length, hard at not length is not the issue. Issue is this is totally confusing. Where then how will I hear?
Your Lordship, if I may, if Your Lordship passes one order and directs them to appear under the different headings, that will solve the whole confusion.
Because
In one order, if Your Lordship directs that the GA1 will appear as the adjourned motion.
This process I have to carry out in 100 matters for several days.
এটাই তো চেষ্টা করছি।
So what is your suggestion? Tell me.
Lordship, the interim orders for both the injunctions are expiring today.
Sir,
One of them is already before your
one of them, which one is in the list, I can extend. It's not a problem. The one which is not in the list.
If it may be treated on today's list, Your Lordship, because it was supposed to appear again on the same day, or maybe
Treated to be days list আজকাল আর হয় না বাবা CIS
if
system
a supplementary list, Your Lordship. Otherwise, my interim order will expire because it's an interim order we have been fighting for a long time, Your Lordship.
বলছে আজকে expire করছে.
We have handed over the orders, Your Lordship. এটা না দুটোতে আছে দুটো order.
Which one? This is your order. Show me which application is not in the list and the order was passed there.
Your Lordship will find the suit which is 680 of
আবার বলে suit.
the application IAGA1 with.
Show me the orders.
I have handed over the orders,
This
Your
is the
Lordship.
one. Show me, sir. This is the one. Come on,
667 is not on today's list. 680 টা আজকে আছে, 667 টা আজকে নেই, দুটোই দেখুন।
Give me your matters order which is not in the list. So your application for rejection of plaint. Nabo.
My
The
application.
defendant number 2 has filed
Yes,
an
madam.
application GA3.
That is
My application, Your Lordship.
the interim order is in GA1. In respect of GA1.
तो महा मुश्किल. To be mentioned করে supplementary list করো দুটোর সময়.
Grateful, Your Lordship.
Who is on the other side?
Yes, my lord, I
I am appearing.
Appear
I
at
am
the top. I will simply extend the interim order, then we will have to see.
Very well, Your Lordship.
তোমার লিখটা, thank you.
Item number.
May I be permitted to mention of appellate side matter, my lord.
Why?
Contempt application with regard to the
After January, next.
the medical examination is going to be held on 12th from 12th, my lord.
Next.
Your lordship has directed that it should be rounded up and they have qualified in the PST level. The medical examination will be.
Sir, I cannot take up like that.
But a contempt application for 5 matters, your lordship.
Yes, it will appear in the monthly list, January.
But any day,
Sorry.
any the next week Friday, your lordships are taking the one.
I cannot, sir.
matters, my
I
lord,
cannot.
5 matters only direction is
I
given,
cannot, sir.
my lord,
If you are agreeable, I yes, give it. It will appear in the monthly list of January.
My lord, that will be the contempt. The all the proceedings will be covered completed
All right.
between the times. My lord.
Next.
My lord, it will be
Next.
the medical examination starts from
Sir,
12.
Sir, I cannot take up simply.
My lord, contempt application, it is required to serve a direction from your lordships to serve the copy to the contemptor. I think that will serve the purpose, my lord. Otherwise, this fellow people will not get the job. They are competent, my lord. My lord, your lordships find out that to elaborate hearing. My lord, kindly. Any day next week or day, my lord, my lord, last week of
14th November.
obligation.
My lord, may I kindly to mention item number 14.
Friday. যদি পৌঁছতে না পারি পারবো না। আমার অন্য লিস্টের যা চাপ আছে এখন সেই লিস্ট আগে আমি নেব।
Item number 14, Millard. Millard, it was due to appear today by the order of 10th of September along with all other applications. Millard,
Item number
14. Millard, it's only Millard GA3 is appearing, but my injunction application, which Millard the going to expire on 7th, Millard, that GA1 is not appearing. This is
when the matter will be called on, you would make your submission.
GA1 has to appear. Millard,
That's right. So when your matter will be called on, I will direct the GA1 to appear on the next day.
or Millard, both can appear on 6th along with GA1.
Sir, I will not take up this listed matters on mentioning. Yes. Next.
That is
Yes. এটা কি group 2?
yes, group 2, my lord.
Justice Vishwajit Bosu.
My lord, in this matter, my lord, I am appearing for the unfortunate petitioner. Appearing on behalf of the respondent, West Bengal College Service Commission. My lord. চলছে তো?
Yes. What is the matter about?
Matter relating to, my lord, non-allowing the petitioner, non-allowing the petitioner in re-recommending his name to a college having science stream. Actually, fact is, my lord, that petitioner was recommended by the College Service
A
Commission.
particular college.
You
show me that you can claim that in law.
My
But
lord,
for a particular college, you can
no,
get a
not
recommendation.
particular college. My lord, I have been recommended. Recommendation was made, but subsequently
the recommendation.
it is found, my lord.
So show me the recommendation.
Yes, my lord. Yes. My lord, before that, may I hand over the supplementary affidavit, my lord?
Have you served?
Yes, yes. Supplementary affidavit.
On the prayer of Mr.
সুজয় বন্দ্যোপাধ্যায়।
আচ্ছা, affidavit of service?
Affidavit of service is
আচ্ছা, মাথার উপর ওইটা লিখে দেবেন অ্যাসাইনমেন্টের নোটটা। বুঝতে পেরেছেন? Urgency pleaded and the determination being assigned to this court. Regular determination being
And
assigned to this court. ঠিক আছে? ওটা লিখে দেবেন। তারপর লিখুন affidavit of service filed in court today is taken on record. On the prayer of Mr.
সুজয় বন্দ্যোপাধ্যায়।
সুজয়
বন্দ্যোপাধ্যায়।
বন্দ্যোপাধ্যায়, learned advocate, appearing for the petitioner. Leave is granted to the petitioner to file the supplementary affidavit. Full stop. Supplementary affidavit filed in court today is taken on record. Full stop. Copy has been served upon Mr. Subhranshu Panda, learned advocate, appearing for the respondent number.
West Bengal College Service Commission being the respondent number 6. 4, 5, and 6.
4226. Stroke the College Service Commission. What about the other respondents?
I have served and video service is there.
Are they important for?
No, my lord. No. They are given against my lord College Service Commission.
Service Commission.
Against College Service
All
Commission.
right. Full stop. Rest of the respondents are not represented, comma, despite notice. Yes, tell me. Show me your recommendation, sir.
Recommendation, my lord.
Show me the recommendation. Page
22nd June 2023.
Page.
In my averment, page 9.
I want to see the document.
P10, my lord.
Page
87.
You don't want to go to that college.
No, my lord. Thing is that repeatedly conversation was made and representation was given. Thereafter, my lord, what happened? One writ petition was filed by another petition.
Sir, what is your present grievance? Have you joined this college?
No, my lord.
Pakuhat Degree College?
No, Pakuhat Degree College is not having the science stream. I am a professor of chemistry. But, my lord,
so as principal, you will not join there?
No, my lord, I intended to join, but somebody was given, thereafter another letter was issued to join by one Mr. Sachindranath Bala.
Show me.
But Sachin, may he place the case, thereafter I will show him everything. But Sachindranath Bala, he was not given the appointment by the college authority. Thereafter, he moved a writ application before this honorable court.
Sachindranath Bala was also recommended for the same college?
Same college.
Acha.
Bala.
When? After you or
after me, my lord. After me. Thereafter, my lord, he moved one writ application before this honorable court, and it was disposed of by Honorable Justice Joy Sengupta. At the time of hearing, my lord, Justice Sengupta held that.
Yes. Proceed.
My lord, page 110. That is the order of Justice Sengupta, wherefrom it will be revealed. Bottom of page number 2, internal page number 2, that means 110. It is also true that the college does not have science as subject, and added respondent is a teacher of science. Thereafter, the added respondent means me, my lord. The added respondent wrote the College Service Commission that his case may be considered as appointment of principal in Manbhung Mahavidyalaya. Then he had sought for such post in Sakrail Anil Biswas Sriti Mahavidyalaya, and lastly Minapur College, but no response had been held forthcoming. That was the observation of Justice Sengupta. Thereafter, my lord,
kindly come to 113, sir.
113, my lord.
113, sir. Last paragraph,
my lord. In view of the result, let the college authorities take an appropriate decision on the question of the appointment of the petitioner to the post of principal in the state college in accordance with law and expeditiously prevail within 4 weeks from the date of consent.
In the state college means which college?
State college means, my lord, the Pakuhat College.
Pakuhat.
Mr. Bala.
Coordinate bench direction was the other person was to be considered for Pakuhat College.
Pakuhat College.
So what happened to you?
Thereafter, my lord, being aggrieved by this order, Mr. Bala preferred the appeal. An appeal was heard out in length by Honorable Justice Division Bench presided over by Honorable Justice Harish Tandon. May I please? I want to drink water. Actually, my lord, I am suffering in fever. My lord,
you are not feeling well?
No, I am feeling well. My lord, 126.
If you do not feel well, tell me.
No, I'm comfortable, my lord.
All right.
Page number 126 onwards, my lord. That was the order passed by Justice Tandon, Justice President Biswas.
126.
126.
Yes. What happened?
Your lordship will find in page number 128, In the midst of the hearing, we are informed that the judgment of special bench has been challenged before the apex court and notices have also been issued therein, and in fact was fixed for hearing in the month of December 2024. Since the matter could not be taken up by the apex court on the said date, the next date of listing has not yet been listed. Since the apex court is in session,
That's on section 10.
My lord.
So section 10 has been decided. That power is there.
My lord.
It has been decided to be intra vires.
In Sudeshna Lai's case, I have annexed, my lord, in page 27 onwards, all the orders
Then what
passed by
happened?
Supreme Court. And Supreme Court, my lord, held that initially Supreme Court, my lord, injuncted that college appointment should not be made in those colleges, and amongst those colleges, my lord, I am also making application.
So where is the urgency today?
Urgency is, my lord, I have pleaded in my supplementary.
Tell me.
Supplementary. On 29th, I have come to know that West Bengal College Service Commission, my lord, they have issued letters recommending letter of recommendation to some persons, and I have pleaded in paragraph 4 of my supplementary affidavit. 29th October 25, I have come to know, my lord, got it, my lord, paragraph 4 in page 2 of my supplementary affidavit, that thereafter suddenly on 20 and 29th 10 2025, I've come to know from the relevant source that the concerned respondent, that is the West Bengal College Service Commission, has recommended names of Mr. Deepak Som, serial number 65, who opted for Sagrail Anil বিশ্বাস Sriti Mohammed, and Mr. Giridhari Panda, serial number 12, who opted for Bhattar College Daton on 29th October 2025 in terms of the purported counselling dated 13th October 2025, and they are likely to be appointed within 2-3 days by the respective colleges. Well, I have annexed that.
All right. Yes, Mr. Panda, what is your instruction?
The writ petition filed by the writ petitioner in the year 2025.
Don't take steps for 7 days, go before the regular bench.
We have issued a recommendation letter.
Yes, no further step.
Well, then, my lordship, kindly direct to the particular call. Is not well. হচ্ছে না তো
না না চলছে তো ওটা
চলছে কিন্তু কাজ হচ্ছে না
হ্যাঁ চলছে তো শোনা যাচ্ছে
we have issued a recommendation letter and our my lord function and my lord is okay
কি হয়েছে মাইকটা ও তো অত অমাইক নয় it's not that অমাইক
because that particular college lordship my lord the authority to issue appointment letter. So unless and
so why you have bypassed him?
No. This is my lord the subsequent the selection where the my lord decision counselling has been held, that is pertains to selection of 2024.
And what happened to him?
Petitioners, my lord, the 2022 selection petitioner was empaneled, but he was participating in the counselling. He opted for the Pakua Hart College. Pakua Hart College
did not have the science stream.
Correct. He made a representation before the authority, and two type of representation. Firstly, he do not want to join in the said college, and he wants a time, 1 month, 2 months, 3 months. Thereafter, college authority, that particular college authority, Pakua Hart College, has wrote a letter to the West Bengal College Service Commission during the validity of panel that the person do not wants to join.
Oh, the panel expired.
No, panel. No. Within the panel, another waiting list candidate, Sachindranath Bala, was recommended. But the college authority college authority refused to issue the appointment letter in favor of that Sachindranath Bala. Sachindranath Bala filed a writ petition. In that writ petition,
these are the orders. Sachindranath Bala was directed to the appointment at Pakurat.
Yes. But despite that, the Sachindranath Bala, but the college authority did not allow and pass any order. And in the meantime, Sachindranath Bala preferred an appeal, and the appeal court has passed an order. That is whether the college authority has power to refuse the recommendation or not. And that is pending before the Supreme Court. That's why the Honorable Division Bench has not decided as yet. In the meantime, 2000 panel has been expired, and the petitioner, I mean, honestly saying, but the petitioner has made several representation. because of the issue is pending before the Honorable Court. That's why College Service Commission has not taken any steps. In the meantime, 2020-24 advertisement was published, and the selection was conducted, and panel was published, and the recommendation has been made. Because there is no injunction. Neither the Honorable Vishwas.
So what will you do now?
Subject to correction, only one can be done. Lordship kindly direct to the College Service Commission. The representation, several representation has been made. It is part of the let the writ petition be treated as representation and direct to the College Service Commission to consider his
take a reason or pass a reasoned decision on it.
Otherwise,
That's right. Otherwise, no scope.
Considering the Sudeshna Ladi's case, my lord, judgment passed by Honorable Supreme Court.
Part of the writ petition.
My lord, I can show you, lordship. I'm sorry.
No, Mr. Counsel, look at it. First thing, panel has expired. Your panel, the very panel where you were recommended.
But my lord, as per that Purushottam judgment,
correct. So let the College Service Commission consider your case after granting you an hearing. This much. No interim order can be passed.
But my lord, things that they will we'll hear after 2 months. In the meantime, entire
I will direct them to hear you within 6 weeks.
My lord, only my lord, I can show one.
Mr. Counsel, there is no scope. Because good, bad, ugly, indifferent, a third party right has been created for the post of principal at that Pakurhat College or whatever.
In other vacancies are there, my lord.
That's right. So I cannot do
my
that.
My learned friend can ask his client.
No, that is not the job of a court.
Coordinate bench of this court, my lord, already passed an judgment, my lord. My lord,
I can advise send it for recommendation. I mean recommendation or consideration.
Short time and before
within 6 weeks.
My lord, only one thing, my lord, as per statute, my lord.
Because of he is afraid of timing. Because of in the meantime, if the college authority issue an appointment letter, then his entire effort to be my lord fast.
No, I will direct the college authority wait for 6 weeks. Then,
my lord, I am only one submission, my lord.
Sir,
that I admit.
I will not pass any interim order.
My lord, my lord,
because your turn has gone because of your choice. You have not joined. It is you who have not joined.
Then I can demonstrate to you, my lord, how the college authority has treated with the professor, the brilliant scholar, how they have treated.
Mr. Counsel, question is, you have got a recommendation way back in 24. It is your duty to join there. You have a choice not to join. Maybe. If you don't join, then you cannot claim any right or equity on that.
Right.
That's the fundamental. Right. So I at best can direct the college authority, I mean the College Service Commission to consider, and where the college authority, which respondent?
11. Sakrail only Vishwas.
Yes.
11.
I will direct the College Service Commission to complete the hearing and inform you within 6 weeks. And the college shall not take any steps for 8 weeks.
Only one thing, my lord, I will assist to logic. As per statute, the first statute, the principal of a college shall ordinarily take not less than 4 periods of class in a week in a subject taught in the college.
That is also considered in the part of this.
Mr. Counsel, you have not joined. You are no more. You are not at all a principal of that college as of now.
But if there is no subject, they how could this West Bengal College Service Commission?
Sir, first you ought to have joined there. You ought to have joined and take charge of principal. Then those things could have been seen and sorted out. You chose on your wisdom, not to join. The moment you have chosen not to join, no right or equity is created.
That is true. That is fact. That is fact. But my lord, should.
By virtue of a recommendation dated April, আচ্ছা ওটা লিখেছেন তো ওই প্রথমে বোস সাহেবের ওটা তারপর যা যা লিখেছি লিখুন by virtue of a recommendation dated April 25, 2023 Annexure P8 at page 87 to the writ petition. The petitioner was recommended for the post of principal at 1 Pakua Hat. Eta bold likhben didi. P capital, PAKUAHAT, degree, D capital, college, C capital. Bracket for short, the said college. By the College Service Commission. The petitioner is a science teacher, and since the college did not have science, does not have any science stream, the petitioner on his own volition did not join the college as principal. The concerned selection process for the petitioner was for the year?
For the year 2022.
2022, paragraph.
By dint of advertisement 1/2022.
Subsequently, in the next selection process for the year
2024.
2024, is he a party? Yes. The respondent number 10 was recommended.
2022. Respondent number 10, Sachin Adwala, was also recommended, and he also part of the selection process in the 2022.
Acha. No, but after, since he did not join, he was recommended. Oh, তাহলে তো আরো গেল।
Also, because the college authority has not issued.
That's a different issue. আচ্ছা কেটে দিন। কি বললাম? পড়ুন। The concerned full stop. Since the petitioner opted for not joining for the post of principal at the said college, the respondent number 1 was selected from the relevant panel and was recommended for the post of principal at the said college.
Number 10.
Respondent number 10, the Didi. Respondent number 10. Hello? For whatever reasons, paragraph, the college authority being respondent number 8 and 9 did not issue the appointment letter in favor of the respondent number 10. First up. The respondent number 10 filed a writ petition. When a coordinate bench by its order, judgment and order dated September 18, 2024, September 18, 2024, at page 109 to the writ petition. আমার কাছে কি এখন একলা আপনি আছেন? আর কি বললাম?
Party to that proceeding.
As directed.
As directed, my lord.
The appointment to be granted in favor of respondent number 10. Full stop. The issue ultimately travelled up to the Honorable Division Bench and then before the Honorable Supreme Court. Oh.
Srinath Bala's appeal still pending before the division bench. The main issue where
appeal is pending.
Appeal is
all right. He would have the division bench and the appeal is pending. Chole asho niche next. The record shows the petitioner submitted several representations from time to time before the College Service Commission. But the commission has not considered any such representations. Paragraph. Mr. Sujoy Bandopadhyay, learned counsel appearing for the petitioner, submits that till today no appointment letter has been issued by the college authority for the post of principal of the said college, but the same may be issued any day.
Recommendation by the West Bengal College Service Commission, not by the college, madam.
appointment letter.
Appointment letter.
Mr. Shubhranshu Panda, learned counsel, appears for the College Service Commission, submits that
There is no interim order. That's why
there is no scope for any interim order, as the petitioner has already chosen not to join for the post of principal at the post of principal of the college way back in 2024. In terms of the 2022 selection process, paragraph. Way back now, in terms of 2022 selection, paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that once the petitioner chose not to join the college at which he was recommended for the post of principal, in 2022 selection process, there is no scope for passing any order of injunction in the writ petition. However, since the representations are still pending before the College Service Commission, those may be directed for consideration in accordance with law. Paragraph. In view of the above, the petitioner shall serve a copy of complete set of this writ petition along with a copy of today's order upon the respondent number.
Respondent number. Lordship, kindly direct to the chairman. Respondent number 5.
Respondent number 5. Forthwith. Paragraph. After receiving the said paragraph. The respondent number 5 then, upon issuing a prior notice of hearing of at least 7 days to the petitioner and the college authority. College authority ke?
Respondent number 11.
Na, ke jabe.
Respondent number 11. He wants to go malot the respondent number 11. He intend to malot get a recommendation to the college of respondent number 11.
The respondent number 11, where the petitioner intends to join.
Intend to issue recommendation by the college.
Intends to join. He intends to join. Intends to join. After issuing notice to the petitioner and respondent 10, and after granting them an opportunity of hearing, shall decide the issue in the light of the case made out in the writ petition by passing a reasoned order in accordance with law. Paragraph. The entire exercise shall be carried out and completed by the respondent number 5. Positively within a period of 6 weeks from the date of communication of this order, and the reasoned order shall also be communicated to the petitioner
and the college authority also.
And the respondent number
11.
11 within the said period of 6 weeks. Paragraph. It is made clear that this court has not gone into the merits of the case made out in the writ petition, and the petitioner and the respondent number 11 shall be free to urge whatever points they wish to urge before the respondent number 5, but the same shall not travel beyond the scope of the case made out in the writ petition. Paragraph. In the event the reasoned decision goes in favor of the petitioner, then the necessary recommendation shall be issued by the College Service Commission positively within 2 weeks from the date of the said reasoning order, and the respondent number 11 shall issue the necessary appointment letter in accordance with law positively within 2 weeks from the date of receiving such recommendation from the college, issued by the College Service Commission. ঠিক ঠিক যাচ্ছে, বলুন পড়ুন। In the event থেকে কমা receiving the recommendation from the College Service Commission. Comments to be issued by the College Service Commission. Paragraph. It is also made clear that this order shall not create any right or equity in favor of the petitioner, comma, if the petitioner does not succeed to his claim before the respondent number 5, strictly in accordance with law. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions,
my submission to be recorded. Without in the year 2024, we have conducted a selection, and based on that, we have issued a recommendation because of there is no injunction by this honorable
ঠিক
court.
আছে, ওই শুভ্রাংশু পান্ডা সাবমিশনে চলে যান একবার। Mr. Shubhranshu Panda appearing for College Service Commission বলেছি। Full stop. ও পরে একটা সেন্টেন্স করুন। He submits that there are subsequently 2024 selection process has been carried out and necessary recommendation has also been issued in respect of
the respondent number 11.
Respondent number 11. আচ্ছা, তার আগে একটা এবার লাস্টে চলে আসুন, তো একটা ইনজাংশন ছোট্ট দিতে হবে কলেজের উপর, বলুন। হ্যাঁ, লাস্টে আসুন। ওই অ্যাফিডেভিট ফাইল করেনি বলেছি না? Since affidavit has not been filed, তার আগে একটা প্যারাগ্রাফ দিন। In the event the appointment letter has not yet been issued by the respondent number 11 for the post of its principal, comma, the appropriate authority of the respondent number 11 shall not issue any appointment letter for a period of 8 weeks
to the recommended candidate.
For a period of 8 weeks. From the date of communication of this order to the respondent number 11. Full stop. The petitioner shall forthwith communicate this order to respondent number 11 also. তারপরে হ্যাঁ উইথ দি এটাকে J2 ঠিক আছে এটাকে ডিসপোজ অফ করে দাও করে দিন হচ্ছে ইয়ে দিয়ে with the above observations and directions this writ petition bold WPA 21 কত 828 21282 of 2025 stands disposed of, without any order as to costs. Enin, Didi. Thank you. Thank you. গলা শুকিয়ে গেছিল মামলা শুরু করে
suffering fever. That's why morning.
Go home, take rest. Yes.
Service matter, group 6.
How it has come?
Your lordship directed for motion top.
আরে motion top no দিদি আপনি বললেন গ্রুপ 2 আমি শুধু বলেছিলাম গ্রুপ 2 গুলো দেবেন বিশ্বজিৎ বোস সাহেবের হ্যাঁ দেখান আপনি কি করবেন দেখান আরে সিনিয়র অ্যাডভোকেট সাহেবকে দেখান
ফর্মে ফিল আপ ফর্ম
দেখান মিস্টার বন্দ্যোপাধ্যায় লুক এট ইট আসুন since this writ petition actually pertains to group 6 but by mistake the classification heading has been mentioned as group 2 a group 6 group 2 gulo bold hobe romane hobe on the presentation form comma due to want of determination this writ petition is directed to go out of the list and to appear before the appropriate court.
Leave may be granted to correct.
Paragraph. Records are directed to be sent to the appropriate court forthwith. Paragraph. Leave is granted to the learned advocate on record for the petitioner to cause the necessary correction in the presentation form and the writ petition wherever it is required, insofar as the classification list is concerned. Thank you, Mr. Bandyopadhyay.
Yes. Somebody has left his spectacles.
Oh, রেখে দিন আপনাদের কাছে এই প্রদ্যুৎ কে চশমা ফেলে গেছে রেখে যেও This is group 2. Sure. No mistake in filling up.
Admission process in a B.Ed college has been suddenly hijacked in the midstream. And that's why
for the police authority.
But education,
abduction, kidnapping, whatever.
That's that. Had it been an abduction, very well. Kidnapping, very well. We could have gone. But this is a new ploy. Now, this is through change of email ID and password. Not university authorities can do anything, despite orders of this honorable court, despite NCT having settled the issues. Now, each college is required to disclose a phone number, an email ID, and a password is given for the purpose.
But where is the urgency, sir?
But 7th is the third phase. It has commenced. The third phase of admission has commenced. 65 students have already been admitted. Now, in the midst process, it has begun from 30th of October. Suddenly, when I wanted to upload the student details for the purpose of registration, who have already been admitted, I found that I can't have an access to the portal.
Money paid.
But please see two orders of this, the order passed by your lordship and not the two orders passed by the NCT and not the university itself.
I have passed.
But in one round of litigation, when some alteration in the memorandum of association of the society was under challenge, the respondent number 4 had intervened and your lordship was pleased to allow his impediment in the writ petition. He filed a writ petition challenging the annulment of the alteration number 1 and why the university has changed the email ID and the password in my favor.
No interim order passed.
No.
Now, NCT passed an order that very well the status quo should be maintained all along, and I have been affiliated with the email ID in the current process 2025-2027 session.
You are appearing for whom? The college or the students?
Yes, the number one, the college, and number two, the president of the society.
That is also the college. এই ওই আলমারিটা বন্ধ করো, ইঁদুর ঢুকে যাবে। কি বললাম?
Those boxes also need to be taken care of.
Thing is, the students have already deposited money with the college, right?
I have a 100 intake capacity. 65 have been admitted.
Then
20 plus 45. 20 have been uploaded in the first phase.
Then what happened?
When I wanted to upload the details of the next phase, the second phase, 45 students, I found that I can't upload.
Acha.
Now the third process has commenced from 31st of October. So
which is the university?
It's Baba Saheb Ambedkar University, the B.Ed college.
Yes,
please have a look at page 52 once.
Yes.
That's the NCT communicating to me change of email ID, phone number, and website of the institute, so and so.
Institute means
college.
College. So your email ID and your identity has been changed. Web identity.
Please refer to your letter on the subject cited above, wherein you have applied for the change of email ID, phone number, and website of Deven Mahato Teachers Training Institute, so and so address.
So how is it relevant?
I wanted to show that this is being acted upon till 2025. In the second phase, this is in my favor.
You want to show that this is the email ID which is still there, which was still there, which was given to the students who applied and deposited their money.
Admission process already undertaken.
Acha, then what happened? Then suddenly the university has changed your identity.
So on this basis, university has also changed. Please come to page 54. Please only
done.
Now affiliation done with this email ID at page 153, second volume.
দেখি second volume দেখি এখানেই আছে very well done.
This change of email ID was challenged in a writ petition. I need to show to your lordship the prayers.
Challenged by whom?
By some other Mr. Bhattacharya's client.
Who are they?
Who was an erstwhile president. He says no, the email ID should be in my email.
Oh, so it was an internal management
yes, your lordship's order, I shall refer to that.
Then what happened?
Please come to page 132.
No, but ultimately that email ID remained.
This email ID
remains. In the time these students, this cluster of students applied. Now what? Then what happened?
I can't upload the details of the second phase of 45 students.
Who changed?
Probably the university, because the university gives the password.
Because the NCT order to them.
Who is for the university?
I am for the university.
Yes, sir.
We have not unilaterally changed the email ID. Whatever we have done pursuant to the communication made to us by the NCT. And NCT is not the party. NCT is the relevant party. They have purposely not made them.
Show a copy to him, Mr. Mujumdar.
Even today, this email ID is being uploaded in the website of NCT.
Status we have downloaded.
This what we have received.
This.
So NCT is required to be heard.
Whatever we do, for the time being, please restore this.
For the time being, those who
this is in violation of court's order.
Yes. For the time being.
Of the time being, kindly see. This is again the same problem. Which group will take admission? So presently we have allotted to somebody. Let them take admission. What is the problem?
Oh,
there is no
wonderful.
Because kindly see NCT.
Wait. Students have not committed any wrong.
No, absolutely not.
Right? They are being represented by the college that this is my email ID. Right? So the interest of the student will be of paramount interest.
Absolutely.
How many students?
I have an intake capacity of 100, out of which 65 have been
I record that 65 has already has been admitted. They have been admitted. University have granted the permission.
So we have to upload. The first 20 has been have been admitted.
Uploaded. 20 uploaded. 45 not yet.
Not yet to
35 yet to be admitted.
yet to be admitted.
If they come. All right. For the timing, I will direct. 25 already uploaded. 45 you have to upload.
We will upload provided that like the new sets of persons, not new, the another sets, they will send the data. There is no difficulty. There is no there is nothing to say that these persons, the petitioners have to upload the data. My lord, can you remember the last matter which my lord was taken up in another case? Same.
So very well. But the students have already deposited money.
Rights will be protected. There is no doubt about it.
How, sir?
That the students who have been admitted admitted to the college, not to the particular person in the group.
No, absolutely. That was my last order.
Yes, therefore, this college, as college, we have been the founder of the college, we have been running the college.
1 second, Mr. Varcharia. Mr. Counsel, last week I have passed one order.
Similar thing. One party.
Have you seen, sir? One order I have passed.
Some students have come to take an admission. Let them get admission.
No
and
problem.
Presently the person.
Mr. Bhattacharya, according to you, what should be the solution for these 100 students?
Students who have been already admitted, they must have been admitted to college.
20.
What about the X number?
No. For my understanding, sir.
X number students have been admitted by them through their email. That is the property of the college. The students will be the college property. They will deposit the fees which they have taken from the students to the college fund, and the college authority who are recognized today will take care of all interests of the student. So students do not suffer at all.
Right. But the university must give the
password, email ID. We will not receive any information from the university. Please come to 2 documents. Not absolutely absurd. Not this is being not. I
is respondent number.
Not I have to.
No, I will not.
But I have
to that management dispute.
Yes.
So you will not.
Not please come to 2 pages. Not how can they not change it every now and then? Please come to 52 and 54. Please see page 54.
156, their own order.
And their conscious decision at page 156. Please come to 150. Their own order.
NCT director maintenance. Well, let the NCT be brought in. They will disclose what had happened.
I don't mind, sir. I will.
Today, the status quo as of today be maintained.
I know, but the students' future.
Students will be protected. Lordship kindly take it. The students have been admitted to the college, not to one particular.
Absolutely.
Therefore,
that was my order. The last week order.
Details are with the university. The university will take care of registering them. We are taking them classes. We will take care of their prosecution of studies. Who are they? They are all interlopers.
They are saying your client is interloper. You are saying their client.
Let us see the prayers in their writ petition.
My lord will not
Sidetracking a writ jurisdiction, a court's order.
The university has been looking the affairs from the day one. They have found us. We are the founder. I have given the property. The college is on my property.
So
now subsequently someone will
give me the last order.
So let us proceed in this way. There are different islands in a university.
Can you give me the number?
One island has to be greased, the other island has to be kept.
Computer
right. So unless an island is greased, please come to the 2 documents.
Server থেকে ওই নাম্বার দিয়ে ওই ডেট দিয়ে অর্ডারটা বের করে একটা কপি প্রিন্ট আউট আমায় দাও।
Please see not page 1. Please see page 129 of the writ application, which is the prayers in the writ petition filed by Mr. Bhattacharya.
Mr. Mujumdar, let me be very candid on the issue. I will never go into the internal management dispute.
So will not NCT.
To me, either your client is good, Mr. Bhattacharya's client is also good, or to me, your client is bad, your client is bad. Right? But I must take care of the interest of the student, right?
Right.
So up to 100. You say 100 is the number? Up to 100, whoever the students will apply and deposit the money, their admission should be granted in accordance with law, and the university shall comply with all necessary requirement of law in this regard.
This will probably not ease out the things. Why? Because not this.
Then you add NCT, and then you proceed.
No, it's the NCT's order is already on record. Please come to page 156.
Yes, but it is not a party before me.
They have passed an order already.
This is not a party before.
Please come to page 156.
They have not deliberately made NCT party because that will disclose not many facts.
All right.
But what could not be page 156? What could not be achieved through the court? Not somebody has been greased and not probably managed.
All right.
Please come to page 156. This decision of ERC is Eastern Regional Committee of NCT. Has your lordship got that? The original file of the institution along with other. This is dated 26th of August 2025. That's the date of the decision. The original file of the institution along with other related documents, NCT Act, rules, regulations, SOP, representation of 12th August 2025 and guidelines issued from time to time were placed before the Eastern Regional Committee, and the committee observed the following. The recognition of the institution was granted on 2008, not very relevant. On request of the said my client, the record of the details were altered with the NCT letter of 2024.
These requests to be done on gone through on affidavit.
No, please see this. A letter dated nil received in the ERC on 9th April 2025 submitted by Chittaranjan Mahato, Mr. Bhattacharya's client, had requested that he was the bona fide president of the society till today, and that to this effect he had submitted an affidavit. Note the next paragraph. The above mentioned matter was placed before the 364th meeting of ERC held on 30th April, and the committee decided to forward the documents submitted by Sri Mahato to the affiliating body for verification of the documents and to submit the report. Accordingly, a letter dated 8 May 2025 was issued to the affiliating body for verification of the documents and to submit the report. Now, please come to the next page, the ordering portion. Now, the report of the affiliating body is quoted. Now, please come to paragraph 8. In view of the above, the committee concluded the following. The details of website address, email address, contact number are crucial, sensitive for any institution. As NCT make correspondences on the email in case of show cause notices. So this is very important for the purpose of protecting the interest of the students. The expert body has said so. None of us is an expert.
Mr. Mujumdar, today I am not hearing the writ petition finally.
For the purpose of an interim order.
Interim order, that to the interest of the student.
Right. So the NCT thought that what the interest of the student can be best subserved is by protecting the email ID subsisting as on August 2025. For which the 65 students have been admitted.
Now my consideration will be up to 100 numbers. I will record your submission. 20 is regularized. 45 has not been met. 35 is still vacant. So up to the number of 100, which is the total capacity, the students who shall apply, it may be 85, it may be 100.
Whatever.
Who shall apply and deposit their money, their application shall be scrutinized in accordance with law by the college authority and shall be sent before the university, who shall take course in steps in accordance with law.
Will your lordship please come to page 158?
Then you are before the regular bench.
Right. Now, will your lordship please come to 158 once?
What else you want? Tell me.
Please direct this to be done in terms of 158, the affiliating ID. The affiliation ID.
That would be
so for 20 students, there will be one email ID. For 65 students, there will be another email ID.
Doesn't matter. So long the future of the student is protected, doesn't matter.
But one cannot have an access to the course.
That will be decided after.
Please come to 158 once. Now, I have shown to your lordship, NCT had already decided in August 2025.
Yes.
158 is 11 September 2025. After the commencement of the process, affiliation renewed in this email ID.
I don't disagree. I will record all those. It might so happen that the university has acted in a wholly illegal manner, but it has to be decided on affidavit in presence of NCT.
So as of today,
I will simply pass an interim order to protect the interest of the student.
How it has to be protected? Not your lordships will probably.
That is not the lookout either of your client or of his client.
Every week the university changes its stand.
So long the 100 students' future is secured, fight out amongst yourselves.
The question is, prima facie, your lordship has to be satisfied how it can be secured. Prima facie. No, I am showing to Lordship.
It will be I am satisfied that so long the students who will apply and deposit their money are registered with the university, prima facie satisfaction is there. Complete.
Then for the time being, they'll let them be physically verified then.
Where?
Otherwise, no, I can't upload their details.
You will be stuck at the stage of uploading.
Right.
Right?
Yes.
You will be stuck at the stage of uploading.
Yes.
Correct?
Yes.
Before the stage of uploading, there is no difficulty.
This
you carry out your exercise.
What
They
cannot be uploaded?
Latest communication of NCT.
Yes. No, not every now and then.
This is from the regional director.
That is also that was by a committee.
Mr. Bhattacharya, I will not even take cognizance of this.
Order without as expressed is absolutely not perfect. The university will take care of the 100 students and their future should not be physically admit them, then I'll upload.
Very well. Not actually physically admit them and not upload.
No.
How is that? So the interest of the students, how can Mr. Bhattacharya stand there?
What
I will admit them. I will upload. I'll send it to the university. I'll send it to the university.
Then where is the difficulty?
Today the question is
up to date. Till today, for the 20 students, how have you admitted them?
65 students, there is an admission. I have not been able to. I have uploaded through the email ID which has so far been acted upon. In the midst process, it has been changed, so I cannot upload. So whatever students have been.
Email ID of who's changed? The college?
No, university. That's why please come to 158. Please come to 158 once.
Lordship reads this.
But I have an email ID for an affiliation.
Email ID has been changed.
My email ID.
I'm saying that.
That's right.
The email ID of the college has
correct. Please come to 158 once.
Please now let me understand the technicality of it. Technicality of it from both of you.
Let us not fight together. If not, he is interested with the students. But as I have said, the university will take care of the students.
Yes.
Let me understand. Let me understand the technicality,
Very friendly officer of university.
Technicality, sir. The students apply through email ID of the college.
Yes.
Then?
May I explain?
Yes.
It's a portal. The students has
portal of the college.
No.
The students have to give their choice colleges.
Student has to first give choice that I want to get admit at
college.
Now there are 100 seats. Suppose we got 20 applications, we publish a merit list that yes, you go and get admit. These students now have to go physically to the college and submit their all credentials. In turn, the college authority has to submit all the details through that email ID. When I get those details, we will get admission. Now here, my lord, that matter, there was a de-affiliation. Here the college is affiliated. Only the issue is that the email ID password, the control of the college is with these persons.
I don't mind. Let me.
Persons will send the data.
No, I don't mind which person. Let me tell you.
Whoever is having the
Let me tell you. Today, if you give that email ID, common, one email ID and one password to both of them. Just listen to me. Just to both of them. Right? They will receive the 100 applications, whatever. Those 100 will be uploaded by using that email ID and password before the university.
Practical difficulty.
Email
ID.
NCT will not recognize.
NCT recognizes the college, not the students.
There is a technical difficulty because password is a phone number. Password is a phone number.
Without latest communication on 25th September, which is not NCT says that original college management run by my client, they are the original ones. They have been hoodwinked by these people for some time. That is also recorded in the constitution. Therefore, the latest ID which has been approved by the NCT should be acted upon. Whatever admission they have made, that should be protected.
Yes.
So that these students do not suffer.
So now it boils down to email ID. It's not that easy. Now please come to the prayers in the writ petition.
25th September, letter by NCT, minor with deliberately. Matter concerning the representation of teachers, courts, the matter of the same issue is currently sub judice and is presently pending final resolution before the Honorable High Court. It has come to notice that attempts have been made by an individual named Dhananjay Poti.
Yes.
However, as per records of the ERC, the president of the applicant society, Mr. Chittaranjan Mahato, on behalf of the same institution, that in light of ongoing legal issue and until the matter is conclusively settled by the competent court of law, no action regarding recognition application should be taken in favor of any other person other than Chittaranjan Mahato.
Issued to the registrar, copy given to him.
He was at the challenge before this court. The court will not found suddenly NCT has changed. The court passed a direction about NCTU. How could you change it when the matter is going on? And thereafter, the NCT will have got into the record, found somebody has played the game and changed it.
Please see the NCT's response.
So then it was an
No, but these are things to be decided before NCT.
Correct. NCT has decided. Not
NCT has decided, but I need to hear NCT. Right? But tell me how the students' future for 100 students shall be.
But that's why,
immediately
for the
secured.
time being, I am trying to give a solution. Please come to page 158 once.
Yes, 158. I'm at 150.
Now, this is affiliation. This is renewal of affiliation to this email ID. First 20 students admitted through this email ID for the purpose of verification. Next 45 students also sought to be, whose details are required to be uploaded. I wanted to upload through this. So, the first batch of students already informed through
What
this
is the email ID?
Now, please come to the middle portion of that page, email ID of the college. dharanidharpoti@dmsrc.org.
This is my email ID.
So for the first block, this has already been completed. Second block, half done, wanted to upload, stopped because of technical issues. Third batch, yet to come, process already commenced. Only this process of uploading is due. So for the time being, for the benefit of
Why
the
you are
students,
saying that we will physically verify? You will have to physically verify.
I have to physically verify. Now comes the question of uploading these documents for the students. The university has unfortunately 650 and odd affiliating colleges. It can't physically verify all the time. That's why the process of uploading these documents. It's easier for it. Now, this has been sought to be abused in whatsoever manner. Now, please come to this middle portion. If this has been done for a particular phase, so in the midst process, this should not be changed.
No, but Mr. Bhattacharya, insofar as this 100 student is concerned, if this email ID is used, Dharanidhar, whatever, @ such and such, where will be your problem, sir?
My problem is not that will be not encouraging corruption and interlopers. Kindly come to page 157. How it will disclose? Kindly come to page 157. Now the NCT has got the whole.
Now, sir, whether interloper or not, that has
not it's a question of decision.
Correct, but that has to be decided.
It's only kindly come to that 157. I am showing you that is
Yes, yes.
Sir, this is a email dated 17 June 2025.
Which portion, sir? A157? Yes.
That which is below delay decision and 158 is the annexure which is relying upon. Kindly come to 157. What will happen?
157, where from you are reading?
Top 5.
Oh, sir, yes. The inverted commas.
Yes, sir. This has reference to letter number such and such by NCT. As per this letter, the mail ID was changed to Dharanidhar Poti, the Majumdar's client. The contact number will also change accordingly. In their application for renewal of application in 2024, it was found that one Dharanidhar Poti has been named as the contact person of the college by a governing body where Chittaranjan Mahato was the president. So Chittaranjan Mahato is the president of Deven Mahato Teachers Training Institute. The application for renewal of affiliation for 2025, which is kept on hold because of 2 cases pending. The name of this Dharanidhar Poti comes up as a precedent supported by a resolution passed by a new set of members, none of whom were in the governing body of 2024. In view of the cases pending before the Honorable High Court at Calcutta, University is not in a position to make any comment or change in this matter whatsoever without direction of the Honorable Court.
Yes.
In view of the above, self-contest Then Lordship kindly finds below. Here, therefore, it is admitted that Dharanidhar was a contact person, not the president. Yeah?
No, it is no admission, sir. It is an observation.
Yes,
Right now, correctness,
Then kindly
incorrectness
come to
is not before me.
kindly come to then the 25th September, which is handed over, which is not annexed.
Yes.
Yeah, my lord, 25th September, my lord, the regional director, but this is the my lord, first office of the NCTs, I think. This is regarding the matter concerning the representation of Deven Mahato, Teachers Training Institute. The matter of this said institute is currently sub judice and presently pending. It has come to the notice that attempts have been made by an individual, namely Dharanidhar Poti. However, as per records of ERC, the president of the applicant society is Mr. Chittaranjan Mahato on behalf of the said institution. In view of the ongoing legal case, until the matter is concluded, settled by the competent court of law, no action regarding recognition affiliation should be taken in favor of any other person other than Chittaranjan Mahato, who is the president. Now, the university has not recognized and changed the ID because they found that Deven Mahato was not the genuine person.
No, it's
Whatever
a National Council for Teachers Education.
NCT. Therefore, without whatever admission they have made, I am not going to not graduate that. The students should be protected. Henceforth, as of today, what is the ID given by the university should be acted upon to protect the interest of the students.
Now, the question is, it seems that two rival groups are there for whatever reason. Let's not go into it. Now, Mr. Mujumdar has been accepting the students, particulars.
Has accepted, the students have been accepted.
Right.
What is the necessity? The students should be protected. The students should be protected in spite of change of ID.
So you say that your submission is that let Mr. Mujumdar's client fix 100 students.
No. I say whatever students they have admitted as on date which they are claiming, their interest would be protected.
And what will happen to the future 35?
Future 35 will be get admission in terms of the new ID. Yes. There is no difficulty of getting admission.
No. Yes. What I am saying, for these 100 students, let the university issue an ID through which it will be uploaded.
That's why you have issued it. They have issued an ID. University has issued a new ID,
right,
through which the students will be uploaded.
In favor of Dhananjay.
In favor of the Chittaranjan.
Chittaranjan.
The students will now apply through that portal, through that ID. The students have no difficulty. Difficulty is for their part. I am not speaking other things. Therefore, the students who have been admitted as of today are protected. Students in future will be applied as per the new portal. They will be protected. No difficulty.
That is after fight. Whatever will happen, will happen.
That will ultimately, it will come. Who is going to control? But as of now, the university has recognized a particular ID, which is being on the issue of the.
Now, for this ID, Mr. Mojumdar's client will have no access.
No access.
No access. So, but the particulars are being received by his client from the students.
Whatever they have received, they have to transfer to the university.
How? Physically?
Physically, yes.
That's what I said. Physically. Physically, I shall do.
Till date.
No, as of date.
The admission which they have taken.
And the future admissions also for these 100.
Future applications will be taken by new one.
That I cannot decide at this stage.
It's not university decided. My lord will not be used to pass an interim order on the decision of the university NCT. They have changed the idea.
But that is not before me.
Yes, that's before you. That's why I'm saying without this.
No, but it is not part of the record.
Then your lordship will be passing an order against something which is not on record.
What I was proposing, let all these 100 or 90, whatever, up to what is the cut-off date for application? Receive application?
7th of November.
So 7th of November, whatever applications will be deposited, the 100 of them shall be transmitted to the university.
But not by Deven Mark.
Why?
Not by Deven Mark.
Why?
They have claimed that they have admitted X number of students. Let them transfer to the university.
No, then but by if I say that the balance, what will happen to the balance?
The process is, my lord, the students will apply in terms of the portal ID. There are the students who have not yet come.
My lord, may I say
They will come, then they will come to this portal.
All right. Yes.
My lord, the
You,
thing
what is
till
your
67 students, their petitioners are claiming that they have admitted. Very well, they have admitted.
65.
65. But they have not admitted at their personal capacity. They must have admitted them to the college. So the data must be remaining with the college. So whoever is having the valid email ID, the person should transmit that. It is needless to mention whoever sends us to that. It is not they have taken the
Total
data and
anarchy.
kept it their home.
Total anarchy.
They must have been kept it in the
Total
college.
anarchy.
So if that is kept in the college, so whoever is having the valid email ID, they should send. And now regarding the remaining students, the third phase admission.
I
is
believe
going
my
on.
learned friend is
Whoever
submitting
is
on
having,
But how he
instruction.
One second. How Mr. Bhattacharya will get those particulars of students?
that must be in the college if they have taken admission. That must be in the college. If they have taken given admission, if they have taken all the documents, they must be keeping in the college. So it is not for their tag of war.
If I direct the college that all 65, rather up to 7th November, whatever application they will receive, physically they will send it to you.
Do that.
Let them submit physically. No problem.
Physically they will submit to you.
Yes.
University. Then university will.
What about
That I'm not making any observation.
20 the total number minus 20. 20 we have already uploaded.
Whatever 20
minus
is
20.
uploaded.
Minus 20.
Access an email.
Of course. আসো।
একটা কথা বলো আমরা অ্যাডমিশন নেব আমরা পাঠাবো নোবডি উইল অ্যাক্সেস এন ইমেল আইডি কারণ আমরা ফিজিক্যাল দিলে ওরা অনলাইন
only physical for the only physical only physical documents be sent to university.
Yes, you have to accept it and you will accept.
Yes.
Of course.
I'm not one branch will
Now
the
they cannot
difficulty will
accept
be-
anybody. When we have changed the email ID,
Why?
now they cannot accept
Why?
students because they are not having
Why?
email
That's the thing.
Dispute. That is until
How is the university concerned?
the court goes to the
No, my lord, but they
How
cannot
is the
send more than
university
65 by physical mode because now a online portal is functioning. Whoever in the name of college using the valid email ID.
Such as students are now submitting through that portal.
No, students don't submit. It's an absolutely wrong submission. Students don't submit.
How will you
It's a misleading submission from the university.
my lord
Not the students,
How the student submits, tell
but
me.
students don't
You tell
submit.
Generally,
No, they
students
get admission
apply
in
to
the college.
portal.
College
I am a
approves.
student. How will I apply?
My lord has to go to the portal and give your credential and apply for the say, a particular college.
একটু বসুন
And in return, we will publish a merit list, and then the students will go
So
to
the
the college.
portal will be of university portal.
No. That's absolutely not. That is a rank list.
My lord will not.
But he has given a choice. The student has given a choice. Say one in my college, one in his college. But the student who has given his name in my college, he will come to me. He will give his physical documents. I shall verify whether he has complied with the qualification or not. I shall get the admission fees and upload this in the university's website. But after the student comes to the college, then the communication is between the college and the university,
What
not
he
with
is
the
saying-
student.
What he is saying now, my lord, how now if the students go to them, how he will apply to the portal because he is not having the the petitioner is not having the email ID. So
Please come to 163 university's own document. Please come to 163.
access and take admission of the students. It is not their private property that
Please come to
I
163.
will take admission.
No question of property.
Please come to 163.
The court would be kind enough not to interfere in anything. at
Yes.
this stage.
No, this is the system.
But the students.
Please come to 163. Not university cannot go beyond this today.
Okay, let's see the notice, sir.
Yes, please see the notice.
To come to 163.
In terms of geo number so and so dated 29 July 25, the second phase of admission of students in B.Ed program will start from 10th October 25. The schedule for second phase of centralized online admission to B.Ed program for self-finance colleges affiliated under BSAU. 10th October to 14th October, new application form fill up for new candidates. Submission of preference. Only for the candidates who have already deposited application fee in the first phase but have not taken admission in colleges. Such candidates should go to the option for preference of college, click there and proceed accordingly with ID, password, etc. Such candidates who have already paid the application fee need not pay again. If any previous candidate has not submitted his or her preference, then it shall be presumed that he or she is not interested for second phase of admission. A candidate may modify his or her application form. However, it will be permissible only for that applicant whose application fee has not yet been verified by the university. Once the fee has been verified, no more modification will be possible. Last date of submission of application fee, the candidates who have already paid the application fee need not pay again. Now, this is candidate not who is applying for the admission.
So where do I get where he has to apply?
In a university portal.
In the portal he applies, he chooses the college, then he comes to the college for.
So that portal is an independent portal of the university.
That's for the first phase.
Please, university portal which has got nothing to do with the college. Then the university will shortlist.
Or allot the colleges.
Right?
Merit list.
Then the candidates, then the students.
See the sequence. Publication of merit list preference subject wise. So then the university's function stops. Admission in respective colleges.
Yes, physical mode.
This is in physical mode. This is not online, not in university's portal.
Student data. Then submission.
Wait,
submission
wait.
No, please see the last entry. This will clear out the confusion. Submission of admitted student data in the university portal. Second is directly with the college. Then college uploads this data in the portal.
Now, my lord, kindly see.
No. Kindly answer. Kindly come to the second last entry.
Yes, my lord.
Admission in the respective colleges. How they will be admitted?
These students will go physically to the college, deposit their documents, and get admission. In return, now the last, the college will transmit the data.
I'm saying, student will go physically.
Yes.
They will take their admission in the college, particular college. Then that college authority will physically send you the entire record.
For the timing, let this be carried.
Very well, my lord.
If students are in
But that is with respect to till then the email ID of the petitioner was because now we.
Sir, I am talking. The last date is 7th. 7th, for what it is the last date?
7th is the third phase admission. The students will apply.
Apply.
Last date for application.
Application will be submitted physically.
No, online. Through portal.
Then what is this stage? Admission in the respective colleges?
Admission.
First, there is a portal.
So this portal is of the college portal?
Yes. No. This is a university portal. First, a student has to say that I am a qualified candidate.
So the first student has to apply before the university. So there is no difficulty with university portal?
Absolutely not.
Then you send it to the college considering their merit, right?
Yes.
Now Mr. Mojumdar or Mr. Bhattacharya, let's say both are there in the college. So you have sent it to that college. There the admission will be taken by the respective students physically.
Yes.
Right?
Yes.
Money will be taken by the college. Follow? Then the entire record with the money accepted, it will be sent physically to university.
Grateful to your lordship.
Yes. For 100 students.
Grateful.
We will take admission.
Till that date, whatever students come.
Yes.
Till 7th.
Grateful to your lordship.
And I will say, sir, this order shall not create any right or equity on any rival parties.
I'm not at all there. But I would let them physically transfer everything so far they have admitted.
Yes.
Let them do that first.
Yes.
Then let us see not whether the students come.
Entire 100 will be
Entire 100.
Not admitted yet.
65.
Whatever.
65 as of now.
65 transferred.
65 be transferred.
First.
Plus within 7th.
If anybody comes without following the procedure, that is also
No, we'll do that within the timeline. We'll do that within the timeline. No special timeline.
The college.
The college will do that within the timeline.
College without admission will come to the college. Now, one particular person is saying that we have admitted 65. Where is those 65 materials? Has it been transferred to university?
I'm recording and they will do that.
The date of submission of admitted
The
student
65
data.
will be transmitted with all records and money to the university.
Yes. It commences
And within 7, by 7, whatever they will receive this. That's all.
The time for submission commences from 13th. We will do by that time. Not why is he trying to alter this date?
Even an interloper don't allow
In the supplementary affidavit.
The third phase.
The third phase, not the supplementary
All
affidavit.
right. Ashut.
case of forgery against him.
Please, আপনারা আর বলবেন না। কিনছে না কোর্টে চলে আসছে।
ঠিক বলেছিস ওরা কি করেছিস
সেটাকে অ্যাড করি। সেটাকে অ্যাড করে
But my lord, regarding the third phase, those left 45 students who will take admission. This is because now there is a valid email ID. The person having valid email ID. Still, then, my lord, you can move with the email ID. The persons having valid email ID.
Something wrong. What is his interest so much?
Shoe pinches so much. Shoe pinches so much.
Kindly come to 163.
Yes, my lord, 163.
Right? Students have to apply before university first.
Already done. These are done.
Depending on merits, university will send it to this college.
To the college.
Then the students have to go to the college physically, take admission by depositing whatever documents and money. The college shall collect it. Right? The college in its entirety shall hand over to university.
Yes.
Then where is the question of email ID now?
Now, because my
Except the university email ID? Portal, university portal?
yes, because this process has to be undertaken through online mode. Because there are many students. So since there is a difficulty for these 65 students, we are saying very well they can come physically. But for the rest,
For rest 35 if come,
45,
if come, the same process will follow.
Even 35 will follow the existing procedure.
No.
Why not?
Not existing through email.
That's the procedure.
No. I will say same thing. The students will directly apply through the official portal of the university. University will, depending on their merits, shall
To the college.
college.
Then the question comes that when the
Then they will again physically go to the college. They will deposit their document and money. The university, suppose the college will receive 5,000 rupees with 5 applications. Entire thing will be sent physically.
following the procedure laid down by the law. Otherwise, because it will create an anarchy. You do not know how many money
No,
are going.
this restriction, order will be restricted for this college only.
Yes, for this college only. But this college, you also have to follow the procedure of law.
Sir, what is the procedure of law? The moment I will say online at this juncture, in whose favor I will hold?
Your lordship did not hold it. What was the valid online?
No. They are saying that is not the
Not
valid.
under challenge.
Correct, but that is the dispute.
That's not the dispute. Lord, your lordship will see that this was
A communication made by NCT to register banked upon by a particular faction.
Fight was going on for quite some time. The Honorable Court directed NCT, how could you change in his favor? Thereafter, the NCT decided and said, no, that's
Sir,
wrong.
this repetition will be decided then. But for the time being, 65, whatever he has received, he will hand over.
65
balance.
Balance would follow the procedure.
No, balance, whatever he will receive from following the same procedure, he will hand it over.
Total admission is going on.
Yes, that's right.
Therefore, we are doing it. Yes. These invite absolutely chaos.
No, how? For 35?
Students we have
Students
not
may
yet-
face
students have
difficulty
already
because
applied
who
to
will
the
the
portal.
students will be confused. They will call students. Where will students go? That is the difficulty.
So the allocation is with the students. The allocation is with the students.
Client will say, come to me. Where will the
Recognized by
students go?
NCT and university unless it is set aside after hearing that is valid.
The university will not allot beyond
Yes,
35. The university will not allot beyond 35.
Will not?
Will not allot beyond 35 now. In the third phase, university will not allot beyond 35. So that is in accordance with the merit rank. So these persons come.
Yeah, one thing.
That will make the absolute.
No. I am telling you, I am just asking one question. But the procedure he said, university first will receive all the applications. Suppose 1,000. On the basis of the merit, now third phase, only 35 will go to the college. Right?
If admission is already going on through a particular
No,
portal.
how can it be done?
It cannot be done because
Starting
unless
point.
university sends.
Date of
Because the university already
But the application process has already started. The students are already applying.
Applying at your portal.
Yes.
So you accept those. Where is the difficulty? Then first 35 you have to send.
Yes.
That's the procedure. First 35 physically they will accept and send it to you.
Yes.
That's where is the problem.
Admission commences from 13th November.
Physically,
The petitioner.
Physical what?
Oh.
The petitioner cannot accept for those 35.
This is the story of this college, my lord. He wanted to take over, my lord, by muscle power. Ultimately, it was frustrated.
Sir, for 35, now let us 65 they will hand over. Forget.
And 35 because they will follow the existing portal.
No, but no question of following portal. I tell you why. For 35, the students may apply 500 students for 35 seats. They will apply before the university portal. There is no difficulty.
University sends 35 names.
35.
Names to the
They will send it physically to them.
Yes.
No, not physically. Why would I?
College.
Not physically.
The college.
Portal.
Why?
There is no
Why I have no
physical system. That has been abandoned with.
No, but the portal, that's the dispute pending.
Kindly come to the pair. If your lordship passes that, it is not making the deed absolute. Kindly see the pair.
May I submit one thing for solution? Today 35 students are concerned. It can be 25, it can be 20 or 34.
Maximum 35.
Maximum 35. University has the list, the merit list, whom it is recommending or allotting to which college. Let a copy be sent to both of us. The students be getting we will be taking their admission. We will furnish the copies to university.
The students, they might be get paid twice. Once they will pay,
No student will pay twice.
Why should the students suffer?
How do you know that?
There is a established.
They will pay to the college.
Yes.
Now this
Not to him or him.
he will say I am college.
College is not a person. Somebody is controlling the college. That is the real question.
But how can the university has a say with regard to the internal affairs of the college?
We are saying that kindly follow the procedure. Kindly come through online mode. That
Between
all.
will change and out should
The
have
my
with the
In the midst process, this was changed.
My lord is
And today I'm
proposing something which
have
will
no
make the deed absolute.
I have no access.
This is his prayer.
Show me.
Kindly come to prayer at page 23.
Yes.
Issue a writ in the nature of statutory directing respondents plans to transmit pertaining to instant cases and may be administered by restoring the email ID being so and so. Therefore, by writ prayer is allowed by virtually.
No.
If you say that it
Physically.
physically it cannot be done,
Why?
that the process is that it has to be applied through the portal.
Suppose let us come to a solution, sir.
Or then you have to say this 35 will
Physically,
physically be admitted by the university.
Yes.
Not to
Yes.
Yes.
Yes. Done.
Very well.
Directly admission by the. Yes.
Yes.
Done.
Let us see.
By the
Done.
university.
No.
Now, my lord, who will take the admission fee then? University we cannot. take the-
University will take it. I will direct it.
University will
It
take
will.
it.
Yes. University will accept the fees. University will accept the fees.
There is.
And subject to the result of this writ petition, university will transfer the fees to the college afterwards.
What is the fees? That is again a question. There is a upper limit.
How is he concerned? I am completely concerned. This is the mouthpiece of the college.
1,50,000 is the final. So if they charge 20,000 to today, how much I will charge from a student? Let the court decide then.
No.
What is the admission fee, course fee? How much?
I don't understand. What is being submitted through the mouth of the university is
How much
concerned.
course fee should I accept from the students?
My lord was pleased to pass an order on 22.
There are scheduled fees under the statute.
Direct.
Then I will have to direct no further steps in the selection process.
Yes, no
for
further
the time.
No further.
No further admission.
Admission as of today
No further.
completed. No
No
further.
third phase. No third.
No
And
third
let
phase.
them transfer all documents.
No
and
third
transmit
phase.
to the university.
Of course, for the students we shall submit.
হয়েছে 30 তারিখ ছিল, no third phase.
No.
No third phase.
No third phase. Then 13th.
That you fight it out.
Yes.
No.
No third phase.
They have to
আমরা
transfer
45
the money which they have
আচ্ছা।
received belong to the university.
Why? the actual account
No, if I don't enter into this at that up to that stage, how should I?
Don't pass any order.
No, but the student must be protected.
Only order which is called for that the university will protect the interest of the students who have already been admitted. That's all.
You have already been admitted. Yes.
I think that will create.
But we shall send it through physical mode because we don't have access now.
Yes, that you send it physically.
Please permit that.
65.
Third is no admission.
Whatever has been admitted, 65 has not been admitted.
That's right.
That's right. 65 admitted, 45 I have not been able to upload.
Yes.
But I have annexed those
65,
documents.
max
65.
65. That money they will have to pay.
Yes, we shall.
That money also they will have to send.
Let them say. Why university fee? Entire money, but this is the game.
What entire
money? Why all money? Only the university.
No. Very well.
Admission fee.
I will direct in the affidavit also that they should disclose the entire record.
Yes, of course. But it's already
entire payment made.
Already disclosed in the petition. Already
with the bank details.
All the details have been disclosed in the petition.
আমার রিটে অর্ডার চাই
at page 47.
Yes.
This is the read present read.
তখন আমার নাম ইমেল আইডি ছিল না ও ভর্তি করিয়েছে
তখন আমার নাম ইমেল আইডি ছিল was by Dharanidhar Babu. Here this report was first pass order. The petitioners claim to be the present governing body in the management of Deven Mahato Teachers Training. The petitioner submit that respondent number to University Authority despite repeated application requests being made on behalf of the petitioner. The alleged present management of the college have not changed the relevant user ID. That was their claim. And password of the college on the basis whereof the admissions of the students are done. The students apply for their respective admissions through such user ID and by using password. Today, Mr. Supratim Dhar, though not a party, the petition represents one Chittaranjan Mahato who claims to be alleged actual president of the committee. Such submission is vehemently opposed by Mr. Vishnu Bhattacharya, learned counsel for the petitioners. Since Mr. Mahato is not a party respondent in this petition, who is being represented through Supratim Dhar, this court thinks it fit to add him as a party respondent. Accordingly, learned advocate on record of Mr. Mahato shall add the name of his client. In the area of the respondents, I am skipping over. Then, Lord, kindly come to me, Lord. Next paragraph. Mr. Vishnu Bhattacharya, learned counsel of petitioner, submits that yesterday, is September 29, 2022, was the last day of admission. It was submitted that the entire money which was deposited by the intending students through the existing user ID and password are now lying with said Chittaranjan Mahato and or his group who are not legally entitled to hold the admission of the college since the petitions are the present management. Then kindly come to skip over the two paragraphs. Considering the rival submissions made on behalf of the appearing parties and considering the materials on record, this court is of the firm opinion that the issues involved in this petition can be considered upon affidavits. It is equally true that the interest of the students of the college should be paramount interest and should not be lost sight of this court for the acts of the management dispute. Keeping in view all these factors stated above and on overall assessment of the prima facie stage, an interim measure can be adopted. Since Mr. Mahato has been added the party responding in this petition and now is directed above, he shall affirm in short affidavit. Closing so and so. Admitted, how many students have been admitted for the B.Ed course for the year 22-24? And what is the total amount of fees and allied charges had been paid by such students in favor of the college? Such an affidavit shall be filed positively on or before October 14, and the copy which was done. Then kindly see the entire amount as would be disclosed to such affidavit should be deposited by Mr. Mahato before the registrar, which my client did honestly. The Registrar General in turn shall invest the said entered amount in
usual direction.
Therefore, my Lord, this similar order, Lord, should be pleased to pass in this case also. Let them file an affidavit and send the entire.
But the dispute in that case was with regard to something else.
Same thing, same dispute.
The dispute in that case was some with not a 2022 dispute. Something is sought to be resurrected.
Same user ID dispute.
But this happens with a person who is an interloper and does not know how to run a college. Let him undertake that he will pay that Teacher salaries. Affiliation fees of 1,18,000. It's annexed to the writ petition.
All right.
1,18,000 paid.
Whatever you have received, you have to disclose.
I have disclosed. Yes, of course I shall disclose. It's already disclosed in the writ petition.
And deposit to the registrar. Let us see.
No, now this time they shall deposit with the university.
Yes. এমন করি কাল না লাগে গেছি চেঁচামেচি করতে করতে
That is the beauty of our profession.
Well, we fight for a cause.
Mr. Dhar, now you assist. Us seniors should take. Seniors should relax now. You tell me who is the respondent you are representing.
Respondent number 4, Chittaranjan Mahato.
এখানেও 4 দেখুন Mr. Shaumo Mojumdar, learned senior advocate, appears for the writ petitioners. Paragraph. Mr. Supratim Dhar, learned senior advocate, appears for Mr. Bikash Ranjan Bhattacharya, learned senior advocate, with Mr. Supratim Dhar, learned senior advocate, appears for respondent number 4. Thank you. Thank you. 4. Mr. Parashar Boiddo, learned advocate, appears for respondent numbers 1, 2, 2, 3. 1, 2, 2, 3. Stroke University. After considering the averments made in the writ petition and considering the rival submissions made on behalf of the parties, at the outset, it appears to this court that the two rival groups of managements are loggerheaded with each other, but the college is one. The college imparts B.Ed course to the students at large. Paragraph. The procedure for admission, in a nutshell, is stated at the threshold. The students at large, through the official website, official portal of the university, apply before the university for admission in the B.Ed course. Full stop. After scrutinizing such applications, the university places the candidatures before respective colleges on the basis of their merit assessment. One such college is the respondent number. College is the respondent.
Petitioner.
Petition number
1.
One such college is petitioner number 1. First, the college then receives applications from the students earmarked for that college, earmarked for the college, along with the requisite fees and deposits, the students have to deposit in terms of the prescription made by the college. The college then, through its official email ID and password allotted by the university, submits those applications submitted by the students before the university. And the university then, following its formalities in accordance with rules, completes the admission process.
Registration
completes the registration process. This is the process. This paragraph. Presently, now, Mr. Shoma Mujumdar Lane, senior advocate, appearing for the petitioners, submit that the total capacity of students for B.Ed course of the college is 100. Through the existing email ID and password provided to Mr. Mujumdar's client by the university.
Not existing. Asked why.
Comma, at the relevant point of time, comma, the petitioners had to upload the particulars of the students with their applications before the university for compliance of the final procedure.
Their documents, not application, with their documents.
With the documents, application documents of the students before the university for final completion of the process. Till now, for the present academic year, 20 numbers of students have been admitted by the college
in the first phase.
And their particulars have already been sent and submitted before the university through the existing password and email ID, comma, at the relevant point of time. In the second phase, now, Tapar Likun, Mr. Mujumdar then submits that in the second phase, the petitioners have received applications and documents from 45 numbers of students. But since the existing email ID and password at the relevant point of time has suddenly been changed by the university, the necessary documents and particulars of these 45 numbers of students could not be uploaded with the university portal.
Despite those 45 students having
and
been
as such could not be submitted before the university poster. As a result, these second phase 45, in the second phase consisting of 45 numbers of students, aspirants, could not be admitted.
No, admitted, but their, please see once again the process. Admitted, but their documents have not been uploaded.
As a result, the necessary documents and particulars of these of the said 45 numbers of students could not be submitted before the university. Paragraph. Mr. Mojumdar further submits that the third phase of admission shall commence on
ending on 7th November.
Has already commenced.
Has already come. Submits that has third phase of admission has already commenced on and from
1st November 2025.
November 1, 2025.
November.
Last date is on.
And the last date of such admission process is fixed on
7th of
November 7, 2025.
7th is the last date for filing application. Last date is 14th November 2025.
November 14, 2025. He submits that since this email ID and password has been changed, it is not possible for the college to submit the particulars and details and documents of the last phase students, third phase students, to the university
through online mode,
through its official website. Paragraph. Challenging the sudden change of sudden and unilateral change or alteration of the said email ID and password of the college at the instance of the university, comma, the instant writ petition has been filed. Paragraph. Mr. Bikash Bhattacharya, learned senior advocate, appearing for respondent numbers 4.
Bikash Ranjan, Mr. Bikash
Submits.
Bikash Ranjan Bhattacharya. Mr. Bikash Ranjan Bhattacharya.
Mr. Bikash Ranjan Bhattacharya, learned senior advocate. Thank you. Aging am. Learned senior advocate, appearing for respondent number 4, submits that email ID and password granted in favor of the college by the university is still in existence and is and since his clients are in control and management of the college, by using the same email ID, said email ID and password granted by university, all the particulars and documents of the students can be uploaded easily on the official portal of the university, and therefore the same can be submitted before the university. First, he further submits that the National Council for Teacher Education, bracket NCTE, is already of the view that the petitioners are indulging various illegal activities while conducting admission process of the college.
Petitioner number 2.
The petitioner number 2. কি বললাম?
সাবমিশন আছে
ব্র্যাকেটে ওটা। Petitioner number 2. Full stop. Comma. As a result, on the basis of the complaint lodged before the university has changed the email ID and password.
was lodged before the NCT.
On the basis of the complaint lodged, comma, the university has changed the email ID and password.
Has changed. NCT has directed the university.
The NCT has changed the email ID and password, and as a consequence, the university has also taken steps accordingly. Full stop. Paragraph. After considering the rival submissions of the parties and upon perusal of the materials on record, comma, at this interim stage, this court is of the prima facie view that the two logger-headed rival groups are trying to control the management of the college. And the students' future and the future of the students are in between. This court is of the considered view that the future of the students should be the paramount interest of this court, and the same shall be protected at any cost. On the basis of the said prima facie view, the following directions are passed. A. Insofar as the documents have A. Since in the first phase, since the records and documents for 20 numbers of students in the first phase have already been submitted to the university, no further direction is passed in this regard at this for the present. B.
University should proceed in accordance with their procedure for the purpose of registration of the students.
Last. B. In the second phase, as submitted on behalf of the petitioners, the college has already received documents and particulars for 45 numbers of students and admitted them in the college, and after receiving the requisite fees, comma, the petitioners are directed by way of a forwarding communication in writing stating the details of such 45 numbers of students and the total amount received by them, and also shall state the particulars of documents and records received by the college, and then shall send and transmit the entire record to the university forthwith, but positively within 3 days, 3 working days. 7 working days from the communication of this order. Now, the communication ki petition up to ache from today.
7 working days from today.
From 7 working days from today. The entire amount received on account of the said 45 numbers of students $20 has already been done.
Money is lying with them.
Please wait. 45 number of students shall also be deposited with the university.
Only one submission here. Not these course fees. These are required for running the college laboratories, teachers' fees. Unless
First you
these are-
deposit, sir. This is an interim order.
But minus the expenditure already made. 1,18,000 we paid for affiliation. It's annexed to this writ petition.
Kindly come to my lord.
The
My lord
document is
speaking as
annexed
a
to
order.
this. But if somebody has not pointed out this folly, it's not the court to take note of all these things. But 1,18,000 rupees straightway deposited with the university for renewal of affiliation.
That is a part of the record.
That's part of the record before your lordship today.
আমি টাকাটা কোথা থেকে দেবো?
University has charged this.
First you secure the student, they will keep the
Yes.
accounts
We
and
will
give
keep
it
the
before
accounts.
the regular court.
We will keep the
Regular
accounts.
Submit the details. হ্যাঁ কলেজটাকে বন্ধ করে
We have a college account.
আচ্ছা ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে
We will provide the details. We will
Which has been shown in the audit.
We will
everywhere.
provide the
We are
details
not
before the
spending
court.
money in the
কি বললো?
college
আচ্ছা
account.
We will
wait
provide the details
That is
before the
the
court.
problem.
all right, let me see. Shall be accounted for, and the details shall be provided in the communication referred to above, and the amount after and the amount lying in the hand of the college on account of the said 45 numbers of students shall be deposited to the university with the said communication. Poster. C. For the last phase of admission, whatever number of students will be admitted by the college through a forwarding communication in writing in the similar manner, the entire particulars and records of such students shall be forwarded to the university. Full stop. Similarly, the detailed accounts on account of the said last phase money to be received by the last phase students from the last phase of admitted students shall also to be provided to the university, and the remaining amount after causing the necessary expenses with its detailed account shall also be deposited with the university within 7 days from the date of completion of the said third phase of admission. Paragraph. Next, C. The university shall keep all these money in a separate account and shall invest the same with a nationalized bank in a fixed deposit account.
But the problem which was not pointed out to your lordship on the earlier occasion was that there are prescribed fees to be paid to the teachers.
Salary.
If the entire amount, the salaries is
I
deposited.
have not said entire. You take your expenses out.
That's it. Please provide.
Give the accounts, but give the accounts to the university.
Yes, accounts we shall provide. No problem with that.
Full stop.
But instead of directing, depositing,
Teaching staff, not
instead of
every year's audit we find.
Now first let me secure the student and
Mind
we'll fight out.
Money will go.
And money, let it go. Doesn't matter. It's between the two individuals.
is the merit list to both the
It
groups.
so that so long it is
Staff and non-teaching staff for the
so
up
long
and running
so
of the-
long
smooth up and running of the
Mr. Counsel, so long it is not affecting the student, I'm fine. Money between yourself, two
all
groups.
I'm saying, my lord, money
Next.
should be, my lord, secure.
I have said that, whatever.
Secure, but, my lord is allowing
is
them
not a-
to, my lord, spend the money.
This is not a suit for accounts. So
That-
I have to secure the students, that's all.
Last
that merit-
occasion, my lord,
merit-
we deposited
merit
the
list,
in entirety.
Right.
merit list to be sent to both
I
the
am
parties.
passing an interim order. It's a further considered.
Meantime, they will, my lord, they will spend all the money.
Who?
That's the problem.
Who?
They.
That is,
Mr.
I
That
will
is
not
the
decide
problem.
here.
Our
I will
money
protect
goes
the
to college
students.
account.
Yes, next.
The merit list of the 35 to the both the groups.
After receiving the records and candidatures relating to the candidatures of the students, the university shall process and complete the registration process for the students, for the total number of students,
Rules, because there are certain
in accordance with law, but positively within.
But that is, we will give notification because registration is separate process.
Acha.
We issue notification.
In accordance with law. Full stop. Paragraph.
But in terms of that program schedule, that 7th November is the date for last date of submission of the application fee. But here, as it in course of the argument, it came that the university should submit this or should furnish the
Why?
list of the merit list of 35 students to both the groups.
No, this we will publish in our portal. Why to give them separately? Our portal
college will now but how they will access to your portal?
Now they have no right to access my.
So you have to provide. Don't sorry. Students should not suffer.
Because these students will come to the portal.
That's once again he's going back to the same thing.
35 students applied.
How the college knows which 35?
Somebody is controlling the college.
You must give the particulars. The university shall physically provide a list of the students
allotted balance 35 or whatever, the balance students.
List of the students, list of the rest of the students
allotted to this college in the third
for
phase.
the third phase.
Allotted to this college.
To be allotted to the particular college, being petitioner number 1. কি বললাম করুন for the third phase allotted to the petitioner number 1 positively within
by 4 p.m. of 12th November. By 4 p.m. of 12th November.
Whenever the merit list will be prepared, we will upload it in our portal. So both
how they will access to the portal?
Website, university website.
How they will accept?
Anybody can go to the website. It is not the portal. I'm saying about the website.
Allocation.
Website.
Website you have access.
Both party can access.
Let them disclose it. Then upload the merit list in the website.
In the website.
Let them upload the merit list in the website.
We will upload those 35 students or whatever number in our website.
Very well. Let it be recorded.
Sir, physically na shall upload bolun in its official website. Tapor porun. The particulars of the rest of the students of the third phase. Full stop. Full stop. Positively within?
When the merit list will publish on that date,
That's 4 p.m. of 14th November.
Merit list will publish on 14th November.
4 p.m. of 12th November. By 4 p.m. of 12th November.
That's
the prescribed date.
By the positively by 4 p.m.
of 12th November 25.
On
past publication, then it would be uploaded.
By 13th, my lord.
By 13th. Very well. By 13th November.
13th is admission.
13th is admission.
Simultaneously, both cannot.
Please have a look at this document.
Just saying that if we will upload it on 13th, now if students will go to them, they will admit.
Kindly have a look at it.
Please have a look at their own prescription. I mean the program, the schedule.
Publication of subject-wise merit list. College/subject-wise merit list.
Normally,
serial number 4.
Yes.
Send it in the portal. They will upload in the website. That's the only thing.
That's publication.
কি বললাম?
Publication করে 3 দিন বাদে
By 4 p.m. on November 12, 2025.
By 5 p.m.
By 4 p.m. is there. How can I change?
Portal. 4 p.m. is the portal. Thereafter, we have
Okay, তার মানে ওরা আগে পাবে আমরা পরে পাবো।
separately publish.
By 4:30.
4:30.
Just after.
4:30 p.m. on such and such. এই ডেটগুলো টাইমগুলো বোল্ড করে দেব প্যারাগ্রাফ. It is made clear that considering the urgency and the prima facie case, this interim order has been passed. And this court has not, the interim order has been passed. Poster. Paragraph, the parties shall be at liberty to mention this writ petition before the regular bench for further consideration upon notice to each other.
But somewhere kindly record my submission also that we have changed the email ID by virtue of a communication received by the NCT.
আরে লিখেছি তো
Their submission, not the university submission.
আলাদা কি হবে?
Not gone into the record.
তুমি তো ওদের কথাই বলছো ভাই, আলাদা
সেম থিং। আচ্ছা একটা ওখানে লিখুন, ওপরে চলে যান, কি বলেছে?
আলাদা কি
ফ্যাক্ট কি আলাদা হবে না?
Because university submission has not gone into.
কি বললাম? পরাশর এটা একটু আর্জেন্ট আছে। হ্যাঁ কি বললাম?
They have handed up perhaps a supplementary affidavit.
Yes.
Without leave,
No.
they have.
Last, only 2 submissions.
When?
We were referring to this program. We are referring to this program. This is part of a supplementary affidavit.
Submit that supplementary affidavit.
Oh, দাঁড়াও না বাবা, দুটো শব্দ বলতে দাও।
কি বলেছে?
Not only one submission, not kindly permit us to bring this supplementary affidavit on record with your lordship's leave. Number 1.
কি বললাম? পরাশর নেই, আমি আছে বলেছি। আচ্ছা মাঝখানে কিচ্ছু নেই। আফটার না তাহলে আফটার কনসিডারিং দি রাইভাল সাবমিশনস এর আগে একটা প্যারাগ্রাফ দোকান। মিস্টার পরাশর বৈদ্য লার্নেড অ্যাডভোকেট, রাইডার লাখুন, রাইডার। Mr. Parashar Boiddo, learned advocate, appearing for the university submits that pursuant to the recommendation made by NCTE,
Dated 25th September 2025.
NPTE, dated September 25,
2025.
2025, comma, the university has changed the password and email ID of the college.
Another
আচ্ছা তারপর
leave to impede NCT.
সৌম্য মজুমদারে কি বলেছে? ওই সাবমিশন একদম মাথার উপর লিখুন। অন দ্য প্রেয়ার অফ, লিখেছি মনে হচ্ছে আমার। অন দ্য
No, I have not sought for that.
না একদম উপরে সাপ্লিমেন্টারি এফিডেভিট।
তোমাকে দিলাম,
আমি ডকুমেন্টটা দেখার জন্য নিয়েছি।
তার আগে শুধু অ্যাপিয়ারেন্স আছে, অন তার ওখানে একটা প্যারাগ্রাফ দোকান। অন দ্য প্রেয়ার অফ মিস্টার সৌম্য মজুমদার and a senior advocate, leave is granted to the petitioner to file a supplementary affidavit. Full stop. The supplementary affidavit filed in court today is taken on record. Full stop. Copy has been served upon.
I have not.
No.
A copy. Copy has been served upon Mr. Supratim Dhal and a senior advocate, appearing for respondent number 4. And
It has been served.
Mr. Boiddo, learned advocate, appearing for university in court today. আচ্ছা এবার লাস্টে একটা লিখুন, ওই কি বলেছি পার্টি, ওই লাস্ট প্যারাগ্রাফ কি বলেছি, এটা কি লাস্ট প্যারাগ্রাফ বলেছি? তার আগে একটা লিখুন, in view of the submissions made on behalf of the parties, this court is also of the opinion that National Council for Teacher Education, NCTE, is required to be added as a party respondent in this writ petition. Full stop. Accordingly, NCTE is included as a party respondent. Full stop. Learned advocate on record for the petitioner shall cause the necessary impediment in the cause title of the original writ petition by putting his signature Full stop. Copy of the amended a copy of the writ petition with the impleadment of the added respondents shall be served upon the respondents and also upon the impleaded respondents by the petitioner, along with a copy of today's order. Full stop. The petitioner shall file an affidavit of service when the matter shall be taken up next before the regular bench.
Direction of affidavits.
Before the regular bench.
Like to use the affidavit.
Yes.
Otherwise, the thing will linger. That's
That is not.
for the
First you serve, first you serve, first you serve, first you serve. Go and mention.
They would serve. Petitioners would
That's
serve.
right. Go and mention before the regular bench. I've said that upon notice to each other.
But extremely grateful.
I've given leave to the parties to mention. So you give and mention it.
Regarding evidence.
Yes. Pray before his lordship.
Directly
But
evidence.
extremely grateful and apologies for the.
I have said for further consider. কি লিখেছি পড়ুন? হ্যাঁ, পড়ুন। তার আগে সাপ্লিমেন্টারি অ্যাফিডেভিট তো মাথায়। হ্যাঁ, তার আগে আমি যেটা ডিক্টেশন রেগুলার দিয়েছি। আচ্ছা দরকার তাহলে আরেকটা প্যারাগ্রাফ দিয়ে দিন। ঠিক আছে, অ্যাফিডেভিট দিস। The respondents shall file affidavit in opposition. The respondents, including the impleaded respondent, shall file affidavit in opposition on or before.
Within 2 weeks.
Give me the date. November 17, 2025. Affidavit in reply, if any, thereto shall be filed by November 24, 2025. হয়ে গেল? তারপরে প্যারাগ্রাফ কি আছে? ওই যে parties shall be at liberty. পড়ুন। Thank you.
Grateful to
Thank you.
Extremely grateful to you.
হ্যাঁ হ্যাঁ, ওটা থাকবে, ওটা একদম আপন আর্জেন্সি প্যারাগ্রাফটা থাকবে। পুরো রেগুলার ডিটারমিনেশন একটা মামলা নিতে পারবে আমরা।
But apologies for that.
Lordship সই করেন না? Correct?
আমার ওটা ব্যাকশিটটা দাও না। আমার ওটা ব্যাকশিটটা।
Yes, what is the motion? What is this order?
Subsequently, after that leave, when I filed the written statement, then the application was taken out for taken up for hearing. And in the application, Lordship would see the date subsequent to this. Application that is recorded that the with leave the written statement was filed and then the application was decided and it was in my favor. So written statement was finally accepted in the department.
So, no, if the application is allowed, fair enough, no issues.
So subject to the result of the application.
I am absolutely unaware of this. How can this leave be granted? That satisfy me.
But then another learned another honorable single judge Millard has followed the similar practice Millard of Millard, similar practice has been Millard, adopted by another honorable judge.
Order, I am not interested. Order is fair enough.
So Millard, because
judge order on application is fair enough. But before that, how this leave can be done?
What is being troubling all judges Millard is that, for example, I filed the application Millard. An application is not taken up for hearing. My 120 days expire.
No. Two situation is different. You file an application pending, not taken up for hearing. Act of court cannot harm a litigant. Settled law.
Yes.
But no application is on the board. How this leave can be granted?
But this is why Millard, because today also there is a letter circulated by the Incorporated Law Society, because the problem in the department which all lawyers are facing is that Millard, they kindly refer to this letter. The ILS has also Millard, expressed the same problem. There is no register maintained by the master, and the date of filing of the application is not properly mentioned and is not coming out from the records. So once the application is taken up for hearing, if on that
counsel, how other applications are filed? Any interlocutory application in the
either in notice of motion or in master summons, either.
So this will have to be by way of master summons.
Yes.
Master summons.
Yes.
The moment you take out a master summons, it is obviously has to be in the register. Your case is not that.
My case is twofold. One is that I'm seeking a leave of short service in the master summons.
No, that's a different issue. Yes. Permitted. Right. But the statute says without 12A leave, 30 days. If you cross 30 days, then you have to explain before the court.
Yes.
If the court allows, but not beyond 120.
Absolutely.
That's right?
Yes, ma'am.
Now, without allowing that, how this leave can be granted?
Because if we wait for the hearing of the application, because application is on the way.
On the way and on the board is different.
If Lordship grants me leave today, I will file it. Application.
Why should I give you leave?
The short service leave, otherwise it will be taken up after 3 days.
Different issue, short service.
But otherwise,
why this leave to submit the written statement before the department?
Miss the bus of 120 days. If I miss that bus, then subsequently when the application is finally heard, and if Lordship allows the application in my favor, I'll be out of 120 days.
No. If the application is taken out in between 30 to 120, right? Yes. Application, even if it is not heard, that will not debar you, because the act of court cannot harm a litigant.
My lord is there, but there are other judgments which said that if you miss the 120 days or if the written statement is not found in the record.
But why this? How this leave can be granted?
Give me 1 minute. If it has been also observed that if the written statement is not found in the records within 120 days, then by no circumstances, whatever may be my explanation,
absolutely,
I will not get a chance to file.
Come up with an application beyond 120 days, there's no application in the eye of law.
No, right, but if I come within 120 days, for example, today I am within 120 days. So if today Lordship
grants me, file the application.
I'm seeking your Lordship. I'm seeking your Lordship leave to give short service. I can move it tomorrow or on Thursday. Yes. And on that day, Lordship kindly gives me priority. On that day, if I can explain my cause of my delay, then Lordship permits me to file it on that day. That will
Correct.
also be the same.
But that is also within 120 days.
Within 120 by Friday it will expire. On
Then-
Friday it will expire.
So how this leave will be granted? That I cannot understand.
I can wait till Thursday, Milord. That won't be a problem.
That's all right for this matter.
Yes.
But how this leave in other matters?
My
My lord,
also?
may I just clarify? I'm
Yes,
the
sir,
assisting advocate on record. Lordship, the department does not accept any written statement even after the application, even if the application is allowed beyond the 120-day period. That is the reason, Lordship, there's a new practice which has started where the affirmed written statement is annexed to the application.
Correct.
So that at least one semblance of the written statement comes on record.
Correct.
Lordship, if my lord is pleased to take up my application.
That. I am saying that under which provision of law I can grant this leave to file the written statement before the department, subject to the outcome of application.
With leave of Mr. Dasgupta, may I just add on, Milord? Why this practice came and was followed by Justice Rao was because of an division bench order presided over by Justice Sen. Milord, there the question arose that the Order 8, as amended by the Commercial Courts Act, mandates filing of written statement. Your Lordship is aware, Milord, affirmation and presentation of plaint are different. I may affirm it in day X when it was within limitation. When I'm coming for presentation, I have taken my jolly well time and it goes beyond limitation. The court will not allow
Sir,
me.
affirmation is nothing. You can affirm it
That
and
is the
keep it in your drawer.
That is the reason why, Milord.
No.
And Milord, this is equated here.
90 days. So,
This-
Milord, 90 days is your time. 30 days you have
30
your time.
30 plus 120.
Plus 90.
I'm sorry, plus 90.
90 days is the discretion of the court. And the
Absolutely.
discretion stops thereafter.
Absolutely.
So, Milord, if he is after 30 days, there has to be an application, Milord.
I'm not on that. I'm absolutely with you, Mr. Ghosh. But how this can be done? How
Milord,
can
this
we
has
pass
been
this
done, as I was
direction?
saying, Milord, because affirmation, Milord, affirmation within 120 days is not sufficient. One has to file it. No, wait. One has to file it in the department. And that is exactly which the courts will see and the department will see. That is the reason why, Milord,
So that is
applications
the
were
reason.
filed.
That is the reason you have to come immediately after 30 days.
So that has not happened in this case.
So
That's
that
why,
has
Milord,
not.
we
If
have,
that has not happened,
and
then
this has Milord,
you have missed your bus.
Milord, this has been the practice followed.
Practice on
And that
what
is what we are,
basis?
Milord.
Show me the law.
My
Because,
lord, let
Milord,
us come back on
subject
Thursday.
to
Kindly grants me leave to leave of short service.
Service, yes.
The master summons, then
Short service of
and
master
let me
summons,
move it
yes.
to Thursday.
Kindly give a preference to this matter if it can not come in the early in the list.
Very well done.
At least
How this can be done?
Application is dada. Application is
No, leave to file. No, I need the leave to file it for short service.
Not all problems.
Not
This, what they do, they only solve the problem at hand.
That's right. I'm on that.
Come.
I'm on that. I'm absolutely with you today. I'm giving you short service. The matter will appear at the top even before my name. I don't mind. But how I can do
This has
this?
developed.
But
In the
today,
course
if
of
the
this has
Lordship
developed.
even allows the application, I will not be in a position to file it within 120 days. I may have affirmed it.
That's precisely that's your problem. The day 30 days, 31st day. The day it is 31st day, you should have been vigilant. You should not have waited till 119th day, 119th day.
This we have
got
got this grace earlier. That's why we were trying to impress.
No, I cannot follow this. Under which provision of law? Huh?
There's a judgment of Justice Kapoor, Milord.
Show me.
Singly, I will bring it, Milord. Affirmation is nothing, Milord. I argue.
I am absolutely with you.
That is what we are also saying the same thing.
I am saying the same thing. Everybody is saying the same thing, that affirmation is nothing. You can get it affirmed, keep it in your drawer. Doesn't make any meaningful thing. I am saying the endorsement is said, leave is granted to file this written statement with the department subject to the outcome of the application and subject.
This was an order, Milord.
There are, Milord,
Followed, Milord, by the bench presided by Justice Arindam Mukherjee sitting in courtroom number 23. But that was changed by Justice Kapoor. He said, Miller, no,
This
you
is
can't be
Justice
done.
Justice Kapoor's judgment. Justice Kapoor's leave.
Then, Miller, there is a subsequent judgment.
No, no, Milord, this is my learned senior friend is incorrect in this. Milord,
Show
in
it to him.
particular.
He has just
Totally
shown
not
me
aware
this.
of this practice.
এটা আবার এটা নিজেই তো বলেছে হবে।
This has
Yes,
developed
only.
because of the
And then Justice Rao followed it throughout.
There are divergent views, so Milord, one honorable judge
My
passes
lord,
away.
my lord, let us.
The law, I am absolutely with you.
In this matter, it does.
One of the division bench judgment that my learned friend was referring to, I had the opportunity of appearing.
Louder, louder.
I had the opportunity of appearing in that division bench presided over by Justice Sen. Possibly there are some passages over there which says at least if the application was filed and the written statement was somehow on record, we could have condoned. It was not condoned.
Somehow on record means if you can annex it to the application also.
Or, my lord, also could have been placed in the record. Why, I'll tell you, Lordship.
How can it be placed?
There is an Emar Shah judgment, the judgment by Justice Emar Shah presiding over in the Supreme Court, where also the written statement was filed in the record on the 34th day. But application was made after 120 days. There the court said no. Since the written statement is on record, we will allow it.
The moment
that is 142, may be considered to be a 142 situation.
142.
But my lord, ultimately it boils down to your lordship's plenary powers. It says
We
that,
cannot override this.
yes. Now, my lord, as my learned friend, junior friend was referring to, it has to be filed. My lord, filing doesn't mean, my lord, acceptance by court. Kindly consider this. Filing of written statement does not mean that the court has accepted the written statement. Kindly bear with me. Filing is within 120 days. The rules, the section says it will not be filed beyond 120 days. But the application made later on, your lordship can accept it. Kindly makes that distinction. Today, your lordship can give the leave to file the written statement. Doesn't mean that your lordship is accepting the written statement to be accepted as a written statement in the suit. Which your lordship will do after your lordship considers the application and deems it fit to be accepted. Possibly one way of looking at it.
Read the CPC.
Amended CPC.
CPC doc.
আরে দাদা সবাইকে মাস করে কি লাভ হবে? আজ কালকে তো তুমিও আসবে দাদা এখানে করতে লাস্ট দিনে, তখন একটা মাঝপথ বার করে রাখো, পরে তো সবাই অসুবিধায় পড়বে।
প্লিজ থাক, ওটা থাক থাক না।
কত বাবা? আরে কোর্টটা তো হয়ে গেছে জজ সাহেব, হয়ে গেছে।
I'll run to the department and file it.
No, very well. Leave granted for short service of master summons. Leave granted. Stamp punch করো। মুশকিল। Unless then where should I endorse?
Master signs.
Until the master signs, it will not be stamp punch.
হ্যাঁ?
What my filing?
কি বলছো ভাই? এটা হয় নাকি?
Master has signed the master summons. It will not get assessed. The anti punching will not happen. Thereafter, the affirmation will happen.
তাহলে মাস্টার সামান্সটা দেখি। তাহলে লিভটা আমি কিসের উপর দেব? এটা তো কিছুই না। এটা হয় নাকি কখনো?
The master will not accept it.
Punching করে
Stamp punching will not happen because the assessment will not happen. Assessment will happen, then stamp punching, and assessment will happen after the master.
I'm not on that. I'm not on that. Mr. Mitro. Kindly take the mic.
It is in a soup. System followed. Earlier, if there was any difficulty in the writ of summons, in the master summons, then usually it was placed before the learned honorable judge, taking up interlocutory matters. Nowadays, my lord, the department decides.
No, just show him the master summons. Can the court grant leave on the fiat of it? There is no stamp punching, nothing.
Stamp punch need be made. But stamp punch, they will say that you put the master's signature.
Exactly, my lord. That is what I meant.
And then we shall allow stamp punch.
Master will say
So
3 days.
before that, the court will grant leave, sir.
No, my
That
lord,
I don't know. You tell me.
but the stamp punch should be allowed.
Huh?
The stamp punch should be
I
allowed.
don't mind. Let him do that. I am open for all. I'm a liberal person, not to worry.
I know.
But the thing is, on the rear part of it, the fiat.
Yes.
When the endorsement will be on the fiat.
Yes.
If an endorsement is there on the fiat like this, what is the value of this document?
My lord, that reliance your lordship will have to place on the advocate on record.
Uh-huh.
That reliance, that it will be properly placed before the master. My lord, that is to be.
Sir, I don't mind. I rely everybody. No issues.
My lord, the master sits over, when we submit it, the master sits over it for 3 days at least. That is the reason we come for short service leave, my lord.
I don't mind. Short service is permitted.
My lord, the short service will only happen when the master signs it and issues the summons. And then I will go for assessment, then stamp punching.
But because
the master will not even look at it, my lord. It will just remain in the master's table. For 3 days, it will just remain in the master's table.
To serve upon everyone. That is the master summons. 3 days.
That is what master summons, my lord. Until and unless my lord grants that if the matter I grant leave. Yes, that undertaking I will have to give.
That is the system now prevailing, my lord.
But on a blank plain paper, a court, my assistant register is endorsing on the fiat, which means the court is endorsing. Assistant register has no power otherwise. So the court will endorse on a piece of paper.
That is the system now followed.
But what is the practice? What is the rule?
Well, had the process of issuing the master summons been quicker, this problem wouldn't have come.
Had I submitted it today, I have gotten the master summons today, this issue would not have arisen. Today, if I submitted, my lord, I will get it on
Even
Monday.
then, short service I can grant, because short service is for minimizing the span of time, that 3 days or 4 days.
My lord, that short service leave, as soon as my lord gives it, I will submit it before the learned master. Master will look at the leave which has been granted by your lordship. Then the master is going to make a signature, enter it on in his.
There, in that division bench matter I was referring to, a master summons was taken out after 17 days or 18 days after lodging, and there is no record that you have even lodged it.
That's why
Nothing. That is the issue which has come up.
That is the problem. You do not have any proof that I have lodged it with the master on 119th day. And then when the master summons comes out, that already 120 days is passed. And the court says, I will only look at the day the master summons has been issued.
Exactly what has been.
Exactly the issue which has been
by ILS.
Pointed out by the ILS.
My lord, the returnable date is put here.
Yes.
On the master summons.
That has to be.
My lord, that before that, and it is signed by the master, my lord, it is then need to be served on the other side. And then, my lord, this stamp punch is now being made as it is a part of the affidavit of service.
Well, there are no bigger barristers in the department. That has become the issue. I pardon my.
That is the system.
I am giving an undertaking.
Sir, I don't require your undertaking. I don't disbelieve.
সাদা কাগজের
কাগজ হাত মুছে ফেলে দেবে জজের সই করা কাগজ।
That is why
I'm on that.
Why I submitted, your lordship will have to rely on us.
No, I don't mind, sir. It might happen that accidentally it might slip away. It may fall down from the record. I don't blame anybody. I no aspersion against anybody, but the same thing. Then what will happen to it? দিয়ে দাও একটা লিভ, তারপর দেখি তো এইভাবে হয় নাকি?
শর্ট সার্ভিস আর থার্সডে মুভ করার জন্য।
হ্যাঁ, নিউ চেম্বার থার্সডে। So what should be there? Leave leave granted for short service of master summons.
Yes, just that much, and appear and to matter
returnable করে দাও। Now the question comes about this written statement.
May I take the leave of your lordship? I came for this meeting.
কাজ হয়ে গেছে ও।
And I am through. On the
My
Thursday,
lord,
I'll again face the
this
hurdle.
issue with respect to written statement is with that
No, no,
filing of the written
hardly,
statement.
hardly facing with the application, not a problem. That's on merit. Whatever is written on the application, either I will allow, I will not allow. Matter ends.
My lord, practically what happens once my lord gives the, if my lord grants the leave, at least in that matter which backsheet I had shown to your lordship, that was given to the current record section. It was given to the master's chamber. The master keeps it only at the current record section. Once the application is allowed, they start working on scrutiny. That is when acceptance happens. That is only with respect to filing. That is nothing more. That is not acceptance. If the application is dismissed, that written statement is
distinction
returned.
I was trying to make filing and acceptance.
It is just
bar
automatically
is
returned.
on filing.
That's right.
So acceptance, your lordship can always accept it later. Merely filing, for example, my lord, I may file any document. Doesn't mean the court will accept it. If I file the written statement with my application, does it mean it's filed or it's accepted? No. But the embargo is filing. So, my lord, this is a one way of possibly, my lord, harmonizing the law and, my lord, the equity in one hand. If somebody comes even on the last day or 2 days before and he hands over the written statement, affirmed and, my lord, in a proper way, court may take it, allowed to be filed, but decide whether it will accept it or not. That's I only, my lord, with the humble, with the deepest of respect and with the utmost humility, I say this is one way of looking at it. But what your lordships is going through your lordship's mind is also another way of, definitely a way of looking at it.
Written statement, like there is no question of acceptance.
Take the microphone.
There's no question of acceptance. It's a question of filing.
Filing.
You file it. If you are out of 30 days, you have an application for extension of time.
In between 30 to 90.
Yes, that application lordship has to consider.
That I will consider.
Yes.
That is all right.
Keeps it, if he is within the 119th day, keep it on the 119th and
May I
decide.
add one point, Lord, that there are matters in this court and orders have been passed where, Lord, similar manner, written statement was filed, application was subsequently heard, and ultimately application was dismissed and written statement was directed to be taken off.
Absolutely, with the court fee, if counterclaim is there.
Yes, apart from the court.
Yeah.
Has happened. It is not that, Lord, I will derive any further right to this process. So only the procedural part is concerned, Lord, that, Lord, lordship, Lord, has to have a liberal view in view of the problems that we face at this side.
Tomorrow, Mr. Ghosh is only going to come and say that your written statement is not on record.
No, let us not go into that.
Personally done nothing.
No, absolutely not. Tomorrow, Mr. Ghosh may be in my position and I may be in Mr. Ghosh's position.
I have suffered it. But that doesn't mean...
And I will be
the
adopting.
first one who suffered because of this.
I suffered it. So I suffered it.
Everybody will suffer.
No, it's not a question of everybody. Of suffering. It's if the law is the law.
Apropos the query that is following.
Mr. Rupak Ghosh's matter, now counterclaim, Milord.
We were only trying to assist your lordship that this is another way of looking at it.
So if the order 8 rule 1 says, Milord, filing.
আচ্ছা মাস্টার সামসটা আসুক তো এন্ডোর্স করে দিয়ে দাও তুমি সই করে দাও
File it on the 100 considers and takes it on record.
এইটা নিয়ে আমার কোনো প্রবলেমই নেই আই ডোন্ট হ্যাভ এনি প্রবলেম উইথ short service of master summons and all.
I am also not standing.
But when the statute is clear, saying 120 days and the rigor is 120 days, filing is there, then how can am I permitted in law to grant that leave? That is what is troubling me.
If he has an application, whatever the ground,
it's a different.
Lordship will allow.
Once the application comes, that's a different.
Whatever the ground is.
That's a different issue.
Application annexing the written statement within 120 days. This is what we are doing now.
এটা দিয়ে দিও লিস্টে দাও না তারপর দেখছি
চলেই
হ্যাঁ no your last day is on Friday come on Thursday I have no issues in granting leave or short service, this, that. I am only troubling with that content.
Here only with the practical solution problems that we face. The books do not always disclose the practical problems.
Suppose somebody comes on 120th day.
Yes.
What will happen? His application will be 121st day, which is not permitted.
No, my lord. If my lord grants the short service leave,
to move it next day, it will be filed on 120th day.
Somebody take a situation. Somebody files it on 122nd day. So the application in the eye of law is not there. Even if this leave is there.
He has to justify 31st day to 120th day by way of an
That justification is within the arm of the court. That justification, sufficient equity can be played. But I don't mind for that. But this granting and leave, whether I'm permitted, that's all. All right, Chalo Dikshit.
We'll come back on Thursday.
Great. Attention to one thing. My lord, earlier there used to be an endorsement as noted as of
Noted as made today.
Yes.
Noted as made today. Yes. Noted as made today. I did. Before Justice Kollanjyoti Sengupta, when his lordship was taking up the interlocutory court.
This limitation part.
Yes, limitation saves. That I understand. Noted as made today.
This
My lord, in lower courts, your lordship, I'm sure, must have had some experience. My lord, it is a very standard practice to file the written statement, even if it is the matter is not appearing. Then make an application. And then the court accepts the written statement, which is filed. Because of this new embargo, we are all, my lord, have to be vigilant. There is no second doubt about that, about the 120th day.
Right,
but if somebody comes on the 118th day,
Yes, Mr.
119th
Sinha.
day, some kind of a leniency can be shown.
No, show him that endorsement. Short service, নিয়ে আমার কোনো সমস্যা নেই। দিয়ে দিচ্ছি।
Mr. Sinha is on the other side in this matter.
Neither here nor there. Can this leave be granted? Can I do that?
This is being done by Justice Rao also not was following the same practice, not subject to the outcome, Lord. This was
Correct, but how do I have the jurisdiction?
Acceptance and not the difference.
Application, yes.
Lord, the written statement, Lord, I think just to avoid the Lord, the complication, Lord, of filing it after 120 days.
Correct.
So, Lord, suppose I am filing the application on the 118th day. Lord, my extension application cannot be decided within the next 2 days. So, Lord, his Lord accepting the written statement, subject to Lord, if the application was dismissed, then Lord, it was rejected because it was subject to acceptance. So, Lord, if the application was dismissed, then not this.
Then it will be taken back.
Taken back.
Same
And if it
that
is accepted,
filing and
then
acceptance.
and
You have to, one has to play with filing and acceptance. Otherwise, your lordship will not be able to save 118th day, 119th day.
This was passed on an application. No, order is on an application.
Oh no.
Subject
No.
That's precisely my question is that.
Application on application.
No, sir, this is written statement. The written statement was filed and
endorsement.
No, I have also done at least 2 to 3 when the application was not even on board. We were trying to file.
This leave
It has been done.
obtained by me, Milord. On that day, same situation had happened. We had carried the.
So long the Mr. Sinha or to all of you, assist me. So long the application is on the board, it is numbered, matter ends.
We can get the leave to file.
Matter ends. If the application is kept pending for the act of court, litigant should not suffer. But if the application is not on the board,
It has to be on an application.
Which should be within 120
It has to be
days.
on an application.
Application has to be.
that's right. That is also that I am also.
Either an application or at least a leave from your lordship to file the application or take out
leave.
master summons. Master summons within 120.
I don't mind.
Within 120.
Yes, I don't mind for that. Short service,
Yes.
master summons.
Yes.
Into suppose
Without
nothing is there.
nothing. Without nothing. No. Just a person coming and saying that
That is what he is saying.
No, my lord, he was, I am sure he was either had filed the
I
application
sought
or was
leave of
taking
short
the
service in the morning
same
at 2
thing
o'clock.
that he is doing
was
today. It cannot be. No judge
That is
will
what I-
accept.
That is what I was.
My lord, no judge, honorable judge would accept just a written statement without either an application
That's
or a
right.
master summons with him.
Absolutely.
Cannot be.
I'm saying the same thing, but he is saying and he is saying no.
No,
He will-
no, my
In
lord.
the morning at 10:30, I obtained the leave for short service.
And
At 2
then
o'clock,
he
this leave
came.
was granted to file in the department because by that time, my master summons was already on.
So show me that. That's precisely I'm saying.
That is,
This is the- that
it is not. It is not recorded as such. It is not recorded as such. My lord.
Master summons leave I have granted.
Yes.
But at 2 o'clock, so I have to wait till.
Short service of master summons I have granted. But so long it is not on the board, unless the number is there, can I grant a leave like this? That is the question.
Application
Lordship
decides after
I have to come back on Thursday with that versus summons and then with this.
Absolutely fine. I have no hesitation. And even I told you the grounds, whatever you make out, hand of equity is long enough. I don't mind for that. But without
Let
anything,
me file the application.
another
On Thursday, I
thing,
will
the master
come back
summons show him. Mr. Mitra has also
summons have already sent for filing.
Not without the stamp punch. Can the assistant register give the leave?
Stamp punching the master
Ah.
summons.
There is no stamp punching on the master summons, but the leave has been granted for short service.
No, the difficulty is not the unless not the it is not the stamp punch. No, the master will not unless not the master signs. They will not stamp punch it.
Unless?
No, unless I'm sorry, not the other way around. Unless the stamp punching is done, no, the master won't sign.
Ulto ta. You said it correct. Assessment now he doesn't go.
Assessment
First said it correct, but then I made a mistake.
So on a blank sheet, the court will grant leave for short service.
Signed by the advocate, not that master summons is being signed by the advocate, not and it is being presented. That is what has been done. Your lordship can lay down the procedure.
No, আমি তো মানে একটা কোনো কাগজ নেই, কোনো স্ট্যাম্প পাঞ্চ নেই, লিভ দিয়ে দেওয়া হবে, সেটাই আমি জিজ্ঞেস করছি।
Should not be normal.
একটা স্ট্যাম্প পাঞ্চিংও নেই।
Stamp punch, they do not take not without the master's signature. That's the problem.
অ্যাসেসমেন্টই হবে না স্যার, স্ট্যাম্প পাঞ্চ তো দূরে কথা স্যার, অ্যাসেসমেন্টই হবে না।
My understanding, the leave is lordship can issue a practice business. I think that will be.
So it comes with the master summons to you. You give a leave for moving it out.
আসুক, দেখা যাবে বৃহস্পতি।
Lordship can possibly issue a practice direction. Not, I think that will save all of us. Not, if not a uniform procedure, which can be followed. But keeping in mind, the difficulties of that 120.
The difficulty is there. Mr. Mitra has also explained. But the thing is, Mr. Ranjanlal Mitra has explained. Difficulty is there. I have allowed that with the leave, but দেখি আজকে একটু মাস্টারকে ডাকতে হবে, কথা বলি। মৌসুমী তো এখন, মৌসুমীকে ডেকে কথা বলতে হবে।
I'll again come back on Thursday.
No, that's all right. I don't mind for that. I'm not that rigorous on procedure, but some sanctity must be there.
Issues lordship will face almost in every 10 matters in this division.
Better একটা drastic কিছু করে দিয়ে appeal করতে। I will be corrected by the higher forum.
These are not available.
Kindly take it from that was the view of the division bench also, that if the application was there, the court could have taken in subject to outcome of the.
I also agree that application had the application been there. I absolutely I agree to
taking
that.
out a master summons is also a form of application. Taking out, getting leave to short serve, and thereafter the master's
punched.
No, that is a different issue. That your lordship can
has to be punched. Then the leave should be granted. That's my.
Can use your practice
point.
direction.
Whatever lordship passes, these orders are not appellable. So lordship will wait
under the
passing. These are not appellable also. These judgment says
not. It will be difficult to implement. Will not leave to short serve. Lord, the master will only sign if there is a returnable date mentioned.
Exactly.
So, Lord, he will not sign, but till he signs, Lord, I can't have it stamped on. So, not that practical.
Exactly, my lord.
ঠিক আছে, এটা তো দিয়ে দিয়েছি, দেখা যাক কি হয়।
Grateful, my lord.
ঠিক আছে তুমি।
আজকে তো থার্সডে আবার আসতে হয়, আর অন্য লিফটটা নিতে হবে।
চলো নেক্সট ডাকো।
Item number 1.
কেন টু বি মেনশন কেন? হ্যাঁ, ওই এইটা এক্সটেনশন ও অ্যারেস্ট অ্যারেস্ট করে কি প্রডিউস করেছে? Yes, What is the due?
Total decretors due.
Take the microphone.
Total due amount is 53 lakhs and odd, out of which 40 lakhs is the principal.
Why should I intervene?
But in the meantime, even yesterday night also, the judgment debtor has paid 5 lakhs because his business is totally ruined.
Doesn't
He's
matter.
selling
How will you pay? Tell me. Why should I intervene?
My lord, what happened in the meantime? He has decided to dispose of one of his property, and accordingly, departmental leave from the government authority has also been obtained. But it is taking at least 2 months' time because the properties are lying in the Odisha. But that is the reason.
But
already 23 lakhs have been paid.
Lordship, I appear for the degree holder. There was a specific undertaking before the Honorable Court in October 2024 to liquidate the dues in 6 equal installments, and that installments were to be completed by 31st of March 2025.
Would have to end.
Would have the entire
completed.
Entire amount was to be liquidated by that time, but still, my lord, 30,61,000 is still outstanding as per the claim as made in the execution application.
That is not disputed, my lord. That is not disputed.
And from time and again, we
Client
have
failed to pay the amount within time. That is not disputed. In the meantime, he has paid 23 lakhs.
This was the undertaking which was given to the Honorable Court when the judgment debtor was arrested earlier also and brought to the court.
Repeatedly, judgment debtor was absent in court.
On the first occasion, he had to be arrested and brought to court. And then, at the time of examination, he had given that undertaking, which is recorded in the order dated 3rd October.
I'm
which is
looking at. অন্য অর্ডার গুলো কোথায়?
এই অর্ডারটা দিন দর্শককে। এই 3rd অক্টোবরের ওইটা 3rd অক্টোবরে আন্ডারটেকিংটা।
Where is the acha, it is the last order. 15th September is the last order.
Yes, my lord.
Why should I intervene? Tell me.
My lord, after 15th of September 2025.
Take the microphone. কি হচ্ছে বলো মাইক্রোফোনটা শোনা যাচ্ছে না?
My lord, after 15th of September, the judgment debtor has paid 9 lakhs. My lord, only 31 lakhs are due.
Only how much?
31 lakhs.
So
My lord,
pay 15?
My lord, for that reason, my client want to pay the amount at a time, my lord.
No.
Well,
pay 15 by next week. Pay 15 lakh by next week.
At least 10. Kindly make it 10, my lord.
Today we are on 4th.
We are on 4th. But end of last week, next week, my lord, by next Friday, Friday week, my client will pay 10 lakhs, my lord.
Friday week, which day?
17th, 14th. By 14th or 13th.
Tell me. 15 lakhs.
But by 14th of November, but kindly make it 10, my lord. But kindly make it 10.
11th November. 10 lakhs. 15 lakhs. So sorry. 15 lakhs by 11th November.
But kindly make it 10, my lord. It will be difficult. His business is totally ruined, my lord.
Since 2024, nothing. What crime have they committed that they will not be paid? Pay 15 lakhs by 10 November.
It is not a case that the judgment debtor does not want to pay. He want to pay.
Sir, that is neither here nor there. Ask your client to pay 15 lakhs by 12th November.
By 12th. But then kindly make it 14th, my lord. Friday, 14th November.
15 lakhs by 14th. 15 lakhs. You admit? Take the microphone.
Yes, sir. Yes, sir.
When you will be paying?
14 by 14, 15 lakhs.
By?
14th.
14th of?
November 2025. I'll pay 15 lakhs.
15 lakhs. Ashun. Where do you stay? থাকেন কোথায়?
চেতলা স্যার।
পাসপোর্ট আছে? হ্যাঁ? Submit it. কোথায়? By tomorrow. Tomorrow তো ছুটি নাকি? Day after tomorrow. He shall submit his passport, right? Deposit it with the registrar union side. বাইরে যান, কি করেন?
আগে নিজে বিজনেস ছিল, এখন নেই কিছু স্যার, একটা অফিসে কাজ করি।
আসুন। The last order dated September 15, 2025 speaks for itself. Poster. Despite specific undertaking given by the judgment debtor as recorded in the order dated October 3, 2024. The judgment debtor has failed to adhere to his undertaking and has not paid the amount undertaken by him. Paragraph, as on date, the total due is around rupees
30 lakhs.
Total due is
30 lakhs.
total amount due and payable by the judgment debtor under the decree
In terms of the execution application method, decretal amount plus interest has been claimed.
Along with under the decree, along with interest.
Yes.
Is rupees
at present 30 lakh 61,000.
30 comma 61 comma
50.
30 61 comma
505.
505 comma as submitted by Mr. Devashish De, learned advocate appearing for the decree holder. Paragraph. Pursuant to the warrant of arrest issued by the coordinate bench dated September 15, 2025, comma, the concerned the jurisdictional police authority has produced the judgment debtor before this court today. From the dock, the judgment debtor has specifically undertaken before this court today that a sum of rupees 15 lakhs shall be paid by him on or before November 14, 2025. First up. Paragraph, Mr.
Somnath Gangopadhyay. Somnath Gangopadhyay.
Somnath Gangopadhyay, learned advocate, appears for the judgment debtor. First up.
It is the
In addition, the judgment debtor has also undertaken that he has a valid passport which he shall submit before the registrar original site through his learned advocate, Mr. Somnath Gangopadhyay, positively on November 6, 2025, and the same shall lie and the same shall be in the custody of the learned registrar original site of this court until further direction. Full stop. In view of the above, the operation of the warrant of arrest remains stayed for the time being. Shall remain stayed for the time being until further direction.
There should be an undertaking for him to. There should be an undertaking from him to pay the balance amount also.
One by one, sir. The matter shall appear under the heading কিসে ছিল এটা আগে?
Examination of judgment debtor.
Under the heading examination of judgment debtor, under the heading to be mentioned for the time being on November 7, 2025.
7. By 14th, he will pay, my lord.
ও আচ্ছা 14, হ্যাঁ 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 হ্যাঁ, ঠিক আছে। নো 6টা আমি মাথায় আমার 6টা ঘুরছে, 6তে ডিপোজিট করবে পাসপোর্ট। November 18, 2025. When the judgment debtor shall also remain present in court, failing which the warrant of arrest shall revive. ঠিক আছে, হ্যাঁ কাস্টাডি, কোর্ট তো কাস্টাডিতে নেয়নি, আমি তো স্টে করে দিলাম। হ্যাঁ রিভাইভড হবে, ও তো কাস্টাডিতে নেই।
Grateful, my lord.
Supplementary list item number 2.
My lord, I am for the petitioner in this matter. This is regarding a letter of credit. My lord, we have been enjoying the interim order for quite some time. It is expiring today.
Last order.
September 8, 82.
Interim order dated, Mr. Ghosh.
The order is dated, my lord, 10th May 2024.
Then extended on 8th September.
Yes, my lord. Lastly extended on 8th September.
Urgent motion আছে, ঠিক আছে, কিন্তু আজ যদি interim order expire করছে।
That's right. So my lord, another matter, similar matter is also appearing as in the new chamber application item 12. They are also, my lord, same parties, interim order same, dated 10th May, that is also expiring today. That was not called on. We were waiting since your lordship had given us leave to for this to be included in the supplementary list. Both interim orders may be extended. Same parties, all the parties are same.
So why this is appearing as to be mentioned?
Because he mentioned, because he mentioned.
Yes, yes, yes.
This was not appearing in the list at all. And that is appearing as new chamber application. Today was returnable for both.
এই আগেরটা আপনি নিলেন, অর্ডারটা কে ছাপলো? একটা আগে প্যারাগ্রাফ দিয়ে দাও, তো শুরুই করতে বলবে। Since a warrant of arrest as was issued and the matter was made returnable today, but the matter was not in the list, comma, a supplementary list has been published and the matter has been taken up for consideration. Right? এই অর্ডারটা লেখো। Yes, madam, you are appealing for?
Petition number 2, Bank, your lordship, against whom the interim order has been obtained by the plaintiff.
কি বললাম লেখো। The interim order last extended since the interim order
আমাদের application গুলো কবে হতো?
passed by a coordinate bench will expire today, that is November 4, 2025. Comma, upon mentioning the matter has been placed in the supplementary list and is taken up for extension of interim order. Paragraph. The interim order last extended on September 8, 2025 stands further extended till January 15,
Your lordship.
2026 or until further order, whichever is earlier. Full stop.
Your Lordship.
Well, the other matter, that is.
Let's see,
Yes.
let's see, let's
Yes.
see. Let's call the list. Wait. Ask your junior to wait at least.
I'll also wait.
You are there on the other side. Your other side?
My other side, my lord, Mr. Anand Datta was there and he was the advocate.
Where is he? Where has he gone?
No, he must be here.
All right. Be
He's
there,
there,
be
she's
there. Be there. Yes, Kirche. Yes, Mr. Datta, be there. Because we have to rise early today. Yes. Kyolo, to be mentioned?
Lordship, I appear for the judgment debtor in this.
1 to 5, and I am for the award holder. Now, my lord, here the
LMJ.
Now, my lord,
Yes, Your Lordship.
6 crore, my lord, public money is due. Now, my lord, on last occasion, execution case of 5 awards, my lord.
At family company LMJ.
No, not a family, not a family. No, not the family.
বলবে কোন রিলিজ করে ফ্যামিলি
না বলেছে তো বলো আমি
না ফ্যামিলি ক্যাম্প নো ইটস নট আ ফ্যামিলি ক্যাম্প
My lord, I'm led by Miss Singhi. She's appearing online for the judgment debtor.
LMG Shipping Private Limited मतलब his only company
It's of Jains. The Jains are the owner. I don't know my lord, what lordship is referring to. Because
কি রিপোর্ট আছে কিসের জন্য
Lordship, am I audible?
Yes, why the matter is appearing to be mentioned?
Today, my lord, is for warrant of arrest was issued. My lord, on last 2 occasions, my lord, lordship sees, my lord, the award holder is now, my lord, is the board of port trust, my lord. Now 6.5 crore is the total due out of 5 awards. My lord, 2 witnesses were produced. My lord, they are not at all aware about anything. So, my lord, there was direction was passed on this Jain to come before. To come before and Navneet Jain. And thereafter, as he was absent, my lord, warrant of arrest was issued. Lordship sees the last order September 15, 2025. Now, my lord, we have complied with, my lord, our part. Now, my lord, whether that has been executed or not, my lord, is not known to us. Or may I hand over a copy of the order? Order ta dao, 15 September. September 15 order ta. Oh.
This is that LMJ group.
Miss Singhi can answer this.
This is
Lordship, this is LMJ shipping. Your Lordship.
Yes, the LMJ has other companies also in the name of LMJ.
No, Your Lordship. Other companies have other names, Your Lordship.
অফিস ট্রেনে কোথায় ছিল তাহলে অফিস ট্রেনে কোথায় ছিল শান্তিনিকেতন
No, I released the matter. LMJ I used to appear, but I cannot recollect there. No, so many matters and so many companies. So
Yes, Your Lordship. They have a lot of companies.
yes,
I cannot assist your lordship on lordship's confusion.
no, but those the family company, the brothers, what the owners' names?
Suresh Jain, Siddharth Jain, Pankaj
Yes,
Jain.
Did you appear, Mr. Deepnath Raj Chaudhary in LMJ?
I knew that lordship used to appear at that time. That is LMG International.
That's connected. Family company. All family. Not only international, I used to appear with them. For one group, I used to appear. For the other, Mr. Surojit Nath Mitra. আসুন রিলিজ করুন এই ঝামেলাই না লিখুন This matter stands released from my list, on personal ground. Full stop. The paragraph. Records are directed to be sent to the Secretariat of the Honorable the Chief Justice for necessary assignment.
1 to 6 are same matters.
হ্যাঁ ঠিক আছে হ্যাঁ আজকে পাঠিয়ে দাও সই করে দেবো আর এই 1 to
1 to 5
1 to 5 একই অর্ডার মানে অর্ডার আলাদা আলাদা হবে কিন্তু একই অর্ডার হবে এটা করে দিই আমি তাড়াতাড়ি সই করে দিই ইয়েস নেক্সট দাঁড়ান বাবা যেদিন চেম্বার ডাকবে আমি করে দিই তুমি মেনশন না দেবে চেম্বার অ্যাপ্লিকেশন আলাদা আমি নিচে বসে নেব তখন চেম্বার হয়ে গেলে টু বি মেনশন এগুলো শিখে নাও চেম্বার আমি যখনই ডাকবে যেদিন
Before my lord rises, my lord.
Item number 6.
My lord, I had mentioned my lord, in the morning, my lord, but my lord had indicated that I should come back, my lord, when the matter is called. My lord, item number 14, my lord, the interim order is going to expire on 6th. Now, my lord, the interim order, the GA1 in which the interim order is passed, that is not on list. That was directed to be listed today along with GA3. So, my lord, it may come with common GA, my lord, on 6th along with GA1. Only GA3 is appearing. So, my lord, I will suffer the millet consequences. This is 14. Mr. Mishra is there, Millet.
Serial number 14.
Yes.
GA3 has come.
But in GA1.
Yes, GA1 interim order is there.
Well, we are respectfully praying before your lordship. Let it appear to be mentioned on.
ঠিক আছে এটা টু বি মেনশনড দিয়ে দাও
Along with GA1, Millet.
1 second.
Along with GA1. 1 and 2.
Along with
GA1. GA1 is not listed. GA1 is the injunction application.
Only the GA1 where the interim order will expire, that will appear.
Yes, GA1. GA1. Very good.
He is appearing as item 4.
The GA1 will remain.
Yes. Let it be.
But
yes.
Number 1 interim order is expiring, it will appear as to be mentioned.
Very good. Very good.
দেখি নাও লিখে নাও give the slip, ask your junior to give the slip. এটা to be mentioned.
The order is there. They have given the order.
6 তারিখে to be mentioned.
Mentioning a slip.
GA1 টা 6 তারিখে to be mentioned.
But item number 9 is not calling.
GA1 না এটা to be mentioned. আচ্ছা আরেকটা যেটা yes Mr. Ghosh, your one. Item number 12. Item number 12 একটা order করো. Where is the other side? Interim order is expiring today.
Yes, today. And one more thing, Your Lordship, our application was also returnable today in the same suit, Your Lordship. Application.
Let me.
But the interim order may be
difficulty I'm facing in interlocutory court. We have not seen that all applications will be mentioned in the cause list but the application will, as one particular application which is returnable, that has to appear on the returnable day separately, and be it new motion, be it new chamber. Then if you submit afterwards that it will be clubbed together or something, then
that was the practice also by your lordship's predecessor, that once there was clubbing order by his lordship, they used to appear together.
That's right.
Either as an adjourn motion or as new chamber application or.
No, but I find that new motion, chamber application, adjourn motion Everything is merged and it is appearing as under new chamber.
Wrongly, your lordship, because my application, which is a chamber
All
application,
right,
your
let me
lordship,
explain the
that is
interim
not
order. Let me say. Serial number?
12. Same order possibly as
Since the
item
interim
number.
order is expiring today, the matter has been taken up out of turn upon being mentioned by Mr. Rupak Ghosh, Learned Counsel, appearing for the petitioner. Paragraph. Mr.
Oyan Dotto,
Oyan Dotto, Learned Counsel, appears for the
defendant number 2 bank.
defendant number 2. The interim order last extended on September 8.
Yeah.
2025 stands further extended till আগেরটা কবে বলেছি
15th of January.
January 15, 2025 or
26.
until further order 2026 or until further order, whichever is earlier.
Obliged you. Very deep.
Item number 9 of your lordship will pass.
Interim order expiring?
No, my lord.
No.
Only the determined lordship by the matter need be released, my lord.
Why?
Because the execution case, my lord, perhaps this court doesn't of 2025. Perhaps this court doesn't have the.
All right, come on the next day. কত অবধি নিয়েছি 6 কল না না 5 অবধি হয়েছিল ওটা কত
9, my lord.
9 wait চল